dental surgeons who are working on contract basis. My only request is it may be taken up today because they are filing affidavits. They said post is lying vacant. Everything is my lord. What has been I have submitted. They have by affidavit. They have said yes, correct.
Very well.
My lord. So
We'll try to take up.
Your Lordship, there is a mentioning I had applied for. Your Lordship, am I audible?
Yes, I can hear you.
Your Lordship, in the matter, in the mandamus writ appeal, this Mat 4 of 2023, there was a direction passed by Your Lordships on 14th of this month that affidavits on opposition had to be filed by 22nd of August. But yet, Your Lordship, the respondents have not taken out any affidavit in oppositions, and therefore, in the lack of directions, Your Lordship, there will be no development in the next circuit as well for this appeal. And this appeal is pending for admission since January, Your Lordship.
My lords, this is completely misconceived, my lords. There is an interim order, my lords. The writ court had dismissed the writ. My lords, by interim order, the division bench has stayed the writ court's order in the main matter. Now, while as the appellant, my learned friend is getting the advantage of that because he is a shareholder of the original writ petitioner, and he has filed a leave to appeal because he was not party to the writ proceedings below. In the leave to appeal, my lords, liberty was given to file affidavit, my lords. That we haven't, my lords. We'll seek an extension, my lords. But there is no prejudice to him. He is enjoying the interim order, even without filing the writ.
The matter for admission is pending since January because
Tomorrow, let it appear as to be mentioned.
In fact, my lords, it can be argued even with the leave to appeal can be argued with the main matter also.
Without the affidavit.
My learned senior is appearing in the.
No, without the affidavit. Do you want to proceed without the
If
affidavit?
the second matter is to be heard, my lords, we'll take
Where is the
extension. my
second
lords.
matter?
Second matter, it's not in the list, my lords.
It is not in the list.
No.
And in the second matter, has affidavit been filed?
Yes, my lords. Second matter affidavits are complete. My learned senior, Mr. Sivabalan, is appearing.
And the stand will be the same in both the matters?
Yes, of course. He's only trying to know the dispute is now between the two writ petitioners, convenient dispute, so they can protract the proceedings. In the second matter, the company is the writ petitioner, and in this matter, they have filed an appeal. The shareholder has filed an appeal. Now, the appellant in the other matter is disputing the fact that this person can independently file an appeal, but eventually both are enjoying the stay because the proceedings are not.
Whatever, if you intend to file
I'll seek
affidavit,
an extension, my lord.
then we can extend the time. Otherwise, if you say that the affidavit filed by your learned senior friend will be suffice.
No, I have to ask. This is different, my lord, because here I have to answer that whether leave to appeal and even
Will be
the
maintainable or not.
yes, even the writ petitioner in the second matter may want to
Very
file.
well, tomorrow is to be mentioned.
My lord.
Lordship.
Item number on.
I am told that my lords have already put it to the next circuit. I don't know, my lords. The order to maybe first date has already gone to the next circuit. Maybe he is not aware.
Your Lordship, there was direction to file affidavit in opposition till the 22nd. Now the 22nd has passed and
Before the next circuit, but if you do not file affidavit in
I'll
the
seek
next circuit, if you seek extension, then it will
My
be
lord,
late.
very good, my lords. I'll seek formally extension tomorrow.
Item number on.
My lord, I am for the petitioner, my lord. My lord granted 1 week's time for filing affidavit in reply.
You want 1 week?
No, my lord granted me last order,
All right.
1 week time for filing reply. My lord, I filed this matured. Now fixed is to be fixed for hearing. If it is possible, my lord, this circuit,
I
otherwise.
do not think it will be possible. Because we are already in the midst of a few of the hearing matters and judgments are being prepared. And we would like to deliver the judgments prior to leaving Port Blair.
My lord, in the event of death, I want to die before a good doctor.
There will be other good doctors also, don't worry. Can we fix up the matter in the next circuit?
Next circuit for hearing.
Please come. Affidavits are over. Stop. Let the matter appear for hearing in the next available circuit, subject to the convenience of the bench.
Simply obliged.
Oblige, your lordship.
Item number 2. Number 24 of 2023.
My lord, I am appearing for the petitioner, my lord. Petitioners, my lord.
Is it a bunch?
No, my lord.
No, my lord.
All different matters.
All different.
My lord.
The way it has been numbered and the parties.
My lord, when the
Must be
case
one.
comes here, when tribunal comes here, when the matters are dismissed, then we
One
file
after another.
one
it
after
comes.
another.
My lords, in this matter, my lords, I have instructions to request for next circuit, but I am otherwise ready in the matter. I have no difficulty in arguing, but I've been instructed because my lords, certain issues are being worked out. Maybe an affidavit will have to be filed, my lords, to place.
My lord,
on
already they have filed an affidavit. It's a short issue involved, my lord. This issue is pertaining to replacement of one contract employee with other. My lord, altogether there were 19 contract employees who were appointed on the basis of a selection process. My lord, when in the year 2022, they published a vacancy notice to engage 19 number of contract employees. We challenged it before the court and the court said, if we are working, you allow them to continue. Despite of that, they have thrown 13 of us.
Whatever, take a stand as to whether it will be taken up today or the next circuit.
My lord, I
Otherwise,
am always ready, my lord.
we will not waste the court's time.
My lord, I have instructions because my lord, certain decisions are being taken as to regarding re-engagement. This is a case of re-engagement. So their contractual term has come to an end. The CAT has said, directed us to consider their request for being re-engaged. Now they are not happy with that. They perhaps, I anticipate, want a mandatory direction that they should be re-engaged. Now, my lords, that on that issue, my lords, the decision has been taken on 10th August. My lords, by the administration, which was also part of the Supreme Court order, which I had shown, my lords. In fact, my lords, in that a specific policy decision.
No, my lord, that has got nothing.
No, please,
My lord, I was the petitioner, so I know very well.
I am only submitting. I am not saying. My lords may see this. This is the order passed by the Lieutenant Governor, and my lords may just yes, please. My lords may please see point number D. My lords may see that in order to rationalize the workforce and to curtail unnecessary financial burden on the government, henceforth, fresh DRMs, even against existing slots of DRMs who have already left, shall not be engaged by any department on its own level in compliance with the direction of Honorable Lieutenant Governor. All departments, organizations, and autonomous bodies shall expedite filling up of regular vacant posts through an open and transparent process as mandated under law and relevant recruitment rules. So, my lord, this has to be considered whether at all any my instructions are oral instructions that my lords now they are discontinued. There's a decision to discontinue with any re-engagement or whoever is working still in within the contractual terms is different. But rest everything will be through open recruitment process and certain relaxed. There's also a scheme for regularization which my lords is also finds mention in the Supreme Court's order. So on the one hand, that scheme will come into force to give regularization to DRMs who satisfy the requirements under the scheme. And on the other hand, my lords, the remaining DRMs, my lords, they'll get certain relaxations, etc., to appear for the competitive recruitment process. But for the re-engagement, my lords, there appears to be that there's a decision which has been taken, but this is oral instruction. I should.
No, why? Because there's an order I can see over here.
Order is of the administration, my lord. I can place it on record, my lords, by way of an affidavit or as your lord.
This has got nothing to do with this case. This order was passed on the basis of an order by the division bench, which was affirmed in a contempt proceeding. The Supreme Court also said you do this. Now, my lord, this has got nothing to do. We are in this case is replacement of one set of contract employee with another set.
By this circuit order,
yes,
they intend to say that they will not replace. They will initiate fresh recruitment process.
So that's a different aspect. This matter is pending before the court of law. The only question is, I say that it ought to be continuous till the regular selection will be made. My lord, there are Supreme Court judgment by an administrative order. They cannot take away the right which is there under the Supreme Court judgments and all. So this has got nothing to do, because my lord, I know the pith and substance of this case. I argued before all the court. So I know this. This has got nothing to do with this case. My learned friend is wrong. I'm making myself clear, my lord. This circular is this applies to all DRMs, including the DRMs in any department. Now the point is that, my lords, the decision is taken not to re-engage any DR. Now this, if had they been in service, it would be different, because there that issue would arise, replacement of contract. That is the settled law, my lords, which my learned senior is relying on. But fact of the matter is that the applicants before the CAT in this case, or the writ petitioners here, they are out of service. That is not disputed. So if they are out of service, they will have to be re-engaged. So if they have to be re-engaged, then that means effectively a DRM will have to be again appointed on contractual basis.
Which you do not intend to do.
As per this order, my lords, a decision is taken because we want to correct the historic wrongs. Every time, my lords, is blamed that the administration has been doing this oppressive practice of appointing DRMs on contractual basis. In fact, even other governments, my lords, will see it's there throughout the country. But maybe it is there in greater measure here because there are large number of government employment. So, my lords, that wrong is being sought to be corrected now by saying that everything will be through regular recruitment. And it's not that we are leaving the current DRMs in the lurch, because.
When will you come up with an affidavit?
Yes,
a short one.
My lord. In fact, once the scheme for regularization comes into being, my lords, it will satisfy. I think it will meet the requirement, my lord. The justice.
No, how will the petitioners be accommodated over there?
What submissions my learned friend is making?
Is a question mark.
Yes, no, I am talking about the DRMs in general, not the specific case.
I am not file any public interest litigation.
This I follow.
Yes.
On the prayer of the learned advocate representing the administration, to file affidavit in the matter. Let
that's a reputation.
affidavit be filed by the respondents.
दूसरे matter में काम आया. Okay, judgments of.
You will be representing respondent numbers 2 and 3.
My lord, yes, my lord. For central government, my learned senior Mr.
Yes, Mr. Lal. 2 and 3. What will be your stand? Would you like to file an affidavit? 2 and 3. By a fortnight.
Yes, yes, ma'am. Certainly.
So, reply, if any, may be filed by a week thereafter. Let the matter appear before the next available circuit.
दोनों judgment के बाद एक copy क्यों निकालो? ना वो अच्छा छोटा order. ये भी निकालो. ये क्या मतलब?
Item number 3.
My lord, I am appearing for the petition. My lord, this petitioner was serving as an A&M auxiliary midwife under the Directorate of Shipping Service. At the age of the age limit of superannuation is 60 years, you know, in Andaman Nicobar administration. So at the age of 59 year 5 months, she was transferred to Nicobar group of island, one Kachal or some place. And my lord, she challenged that because in terms of the transfer policy of the administration, last 1 year, an incumbent can have a choice posting, my lord. So she challenged that before the court, saying that the transfer is malicious, my lord. And on that transfer order, my lord, there are 3 to 4 documents which my lord has to see. Page 57 is the transfer order, my lord. The applicant's name appear at serial number 1, Shaira Bibi, Stewardganj, CHC Bamboo Flat to Pilo Panja under PHC Campbell Bay, existing vacancy. Now, my lord, this transfer she immediately challenged before the tribunal, my lord. Now, my lord, kindly come to the next page, the order of the tribunal. Last paragraph, paragraph number 5. Pendency of this OA will not debar the respondent authority from disposing of the representation at annexure A15 of the original application, particularly in the light of transfer policy. Until such representation has been disposed of, the respondents will not take any coercive steps to compel the applicant to join her transfer place of posting. This is an interim order of 18th of November. 18th of November, my lord.
Yes.
Now, my lord, after this, though they have not considered my representation, after this, the matter was finally taken up by the tribunal, and the tribunal has passed an order, my lord, passed an order which appears at page number 59, my lord.
What was your date of retirement?
Date of retirement, I retired, my lord, in April 2021, 30th April 2021.
All right.
Now,
Yes.
kindly come to page number 59, my lord. The order of the tribunal, my lord, this order is dated 8th of December 2022. Now, my lord, kindly come to the, my lord, the tribunal has reduced the transfer policy and all. Actually, this is not the subject matter at all. I am just placing it. My lord, kindly come to page 62 onwards. The court has considered transfer policy and thereafter the court arrived to a finding at page 62. The court says the respondent have been directed by this honorable court on 18th November 2020 to dispose of her representation at annexure A15 of the OA in the light of the transfer policy. As no decision has been conveyed in the light of such transfer policy, we would hereby direct the addressee, competent respondent authority, to issue a reasoned and speaking order on the representation of the applicant at annexure so and so, particularly in the light of clause 4.6 of the transfer policy guidelines at annexure so and so, and to convey such decision within a period of 6 weeks from the date of the receipt of the copy of the order. Till such reasoned order is issued, no coercive step should be taken against the applicant. The respondent authority shall also take into account the fact that the applicant is an elderly employee with a history of medical incapacitation who would be hypersensitive to the following fallout on the ongoing COVID-19 pandemic. Take note of the fact that there is an acute need of so and so at respondent authorities may take steps to engage a substitute A&M in PHC, giving the transfer policy guidelines, the health condition as well as the age of the applicant concerned. So, my lord, this was the order passed by the tribunal. Now, my lord, at page 6.
During this period, where were you serving?
I was at Port Blair in Community Health Center, Bamboo Flat.
Did you work?
They did not allow me.
Yes.
They did not allow me to work. I have categorically stated in my pleading itself before the tribunal. Now, my lord, page 63.
What about your superannuation benefits, terminal benefits and everything?
They have not given, my lord. Kindly once come to page 63, my lord. Page 63. Now, my lord, 63 is very vital. They say, in partial modification of the Directorate Office Order number so and so, that is the transfer, my lord. The transfer posting of Shaira Bibi A&M is hereby cancelled and she is retained at her place of posting, Subcenter Stevetganj, Bamboo Flat, Port Blair with immediate effect considering her health condition. This issue with the approval of the competent authority. Pausing for a minute, my lord. After this order, that order of transfer goes in terms of the two orders of the court. 18th November interim order and thereafter the final order which was passed by the tribunal. They set aside their transfer. My lord, the moment they set aside the transfer, in terms of the order of the tribunal, I am entitled to all the benefits which accrued during the intervening period. More particularly when there is an order of the court not to harass me. Now, my lord, this order was passed. I am entitled for all the benefit. Now, after passing this order, my lord, up to this stage, the government has acted fairly. After passing this order, my lords, I reported duty at the same place. And thereafter, this order was passed, which is impugned, my lord. Page 65. Now they say, my lord, whereas so-and-so was transferred from the subcenter, and whereas she being aggrieved, she made a representation on so-and-so on ill health ground, being the verge of retirement, and whereas during the pendency of the decision, she filed an original application with the prayer to cause the order so-and-so, and whereas the case was heard by the tribunal on 18 November, wherein the Honorable Tribunal has observed that pendency of this OA will not debar the respondent authority from disposing so-and-so, and whereas in compliance to the order of the tribunal, the respondent has examined the representation of the applicant and communicated the decision dated 8 December 2020, in which it was mentioned that due to shortage of staff and ongoing pandemic, her request for cancel her transfer order cannot be acceded to at this junction, and whereas the said matter was disposed by the tribunal with the following order, my lord. That order which I have read, my lord. And last paragraph, my lord. Last paragraph, my lord. It says, page 66. Now, therefore, pursuant to the order of tribunal dated so-and-so, the matter was re-examined by the respondent authorities on the ground of her medical incapacity, and considering her retirement on 30th April 2021, the respondent authority have cancelled the transfer of so-and-so dated so-and-so and allow her to retention at her place of posting, subcenter so-and-so the directorate order dated so-and-so. Now, my lord, the intervening period from 10th September 2020 till her resumption on duty shall be regularized by granting admissible leave. My lord, only for this purpose, this order was passed. And my lord, by passing this order, whereby said that admissible leave, my lord, the leave encashment which I am entitled, which is a paid leave, that will be deducted to complement that part, my lord, which is not permissible under the law. I am not at fault. You stop me from discharging the duties, despite of an order of the tribunal. And thereafter, in terms of the transfer policy, you arrived to a finding that the transfer is wrong, and it was set aside. Now, my lord, after this, I made a representation before the authorities saying that it is wrong. You cannot do this. The very next page.
Yes.
We have said that, my lord, the entire affairs were narrated in the said representation and requested to regularize the said leave period, treating the same on duty. This was our prayer. And on wide order dated 19th March 2021 at page 70, they rejected this. Now, my lord, the tribunal, while passing the order, not at all considered this aspect. Now, my lord has seen that I made a representation. Once again, representation was rejected at page 70. Now, my lord will come to the tribunal's order, my lord.
Is there any proof that you reported back to duty?
My lord, my pleadings, my lord, I was working there itself. My lord, I was transferred.
Is there any attendance register?
Attendance register, they will not allow me to put signature. My lord, I was transferred from here. I immediately approached the tribunal. Tribunal passed an order. No coercive action is to be taken against me. I reported there. They did not allow. My lord, they have harassed this lady like anything, my lord. Till date, she has not got all the benefit. After pension, she must get whatever be the pension amount. At least provisional pension should have been given. At least she ran from pillar to post, my lord. Thereafter, she got the provisional pension. She has done nothing, no misconduct at any point of time during her entire service career. And my lord, what happened actually in the year 2013 when this lady was posted at Diglipur, my lord, at that point of time while she was proceeding to Diglipur by a government bus, that bus met with an accident because of which she sustained head injury. She went for advanced treatment and all, my lord. And her health condition was not good, my lord. This was one of the ground, and second ground, as per the transfer policy also, you cannot do that.
Where is the tribunal's order?
No, my lord, kindly come to the tribunal's order, my lord. It starts from page number 106, my lord. It starts from 105, relevant from 106. If my lord see where the tribunal went wrong, my lord, from page 110, inner page 6. The tribunal has decided nothing, my lord. The tribunal says on perusal of the representation of the applicant dated 9th February 2021, it can be seen that the applicant stated that as per the order dated so and so issued by the respondent, whereby the order of transfer of the applicant was cancelled, the applicant immediately reported for duty and started discharging her duties at subcenter so and so. The applicant further stated that she has made a representation to the competent authority against her order of transfer dated 17 July 2020 and on 27th of July 2020, but that was not responded to. My lord, it was responded and rejected, my lord. The tribunal not at all considered this. At page 70, it is there. Immediately thereafter, she approached the tribunal, which was disposed on so and so by directing the so and so, my lord. And thereafter, paragraph number 8, my lord. Thereafter, the court has only discussed this, my lord. What are the stand by the parties? The court says, in view of the aforesaid discussion, page 111, para 8, we think it would not be prejudiced to either of the side if the direction is issued to the respondent to reconsider the case of the applicant as per law. Accordingly, the respondent are directed to consider and dispose of the representation of the applicant dated 9th February 2021, annexure A7, as per the extended rule and regulation governing the field within a period of 2 months. Well, this representation was already rejected at page 70. If on consideration claim of the applicant is found to be genuine as per rule, she may be granted the benefit as claimed in the representation. However, all the points are kept open.
So there is no further scope of reconsideration at the end of the respondents.
No, my lord, because they have considered on page 70, they have rejected it. So I say, my lord, what was the necessity to use one more order? When you have already cancelled the said order by 18th January, thereafter it speaks mal of ID, my lord.
Very good.
My lord, first of all, my lords, all pensionary and other benefits are being given, my lords. I've got the proof of that, my lords.
Regular pension.
Yes, my lords. Everything has been given, my lords. The gratuity, everything has been given. Eki copy.
It is
Sorry,
only,
I just have one copy.
It
So
is
that
only-
period, the entire period, the leave encashment amount or
I am only submitting because this is a point of prejudice. I am saying that it is not as if her other benefit. The only question here is that whether that period also it is being treated as earned leave. It is not being treated as break in service or something like that. It is being treated as earned leave. So their contention is that that period should be, they should be able to encash. Yes, it should be treated as on duty. That is the short point, my lord. Now, my lords, we see page 108. My lords, our submission is recorded. The court submission of the learned counsel for the respondents are as under. Representation does not sustain on ground that pursuant to the interim direction, applicant has not joined duty at an existing place of posting. As such, the intervening period was regularized by granting admissible leave to the applicant with a speaking order such and such. Therefore, claim of the applicant that the said period should be treated as on duty cannot be entertained. Now, this is purely a question of fact. I don't see how, my lords, either way, my lords, whether to say that she attended or she did not attend, some authority has to apply their mind and evidence has to, unless they are able to produce some evidence to show that she reported to work, or I am able to, I don't know what negative evidence I can produce that she did not report to work. So they have to produce some positive evidence. Maybe, I don't know, that is for my learned senior to advise his clients.
How many days? How many days? The
This
issue
is a 10 September, long duration.
the
my lord.
Three to 4 months, my lord.
10
4 months.
3 to 4.
Ten-
How much will you get on account of this?
My lord, at least 4-5 lakh rupees will be deducted, my lord, because
For
300.
4 months.
Yes, my lord. Because similarly, one case I have done
Yes.
where 8 lakh rupees, 4 to 6 months of one librarian, there they have deducted 6 lakh rupees, and subsequently by the order of the court, ultimately I have got everything. That
No, but what was her salary? That has to be seen.
maybe that would be amount. I am not an expert.
Depend
to
on
that
the
to
salary, because
Yes.
10 September 2020 till 21st January 2021 is the period.
Yes.
So this
4
period,
months.
4 months.
4
my lord,
months.
4 months.
4 months.
What will the amount be? Because this is the only thing that
My
will
lord,
be
my lord,
decided.
my lord,
Nothing
my
more.
lord, my lord, my lord.
How many days?
My lord, they are the
Amount.
better person because they have expertise hand for this, and I will also ask my client.
Get the figures.
Yes.
my lord, we'll do that.
Then that will be easy for both of you all to
Yes.
know as to how much the petitioner will also get to know how much she will be getting or not getting.
Yes, ma'am.
Is the calculation there somewhere? With
No,
you?
my lord, it is not on record, ma'am.
Not on record.
They might be having because they have deducted that amount
No, they will.
Yes.
from my
will
gratuity and
certainly
annual. There are yes.
Parties will know how much she earns in a month.
No,
but-
definitely.
You also will be.
No,
getting
I
to
will
know.
have it, my lord.
You also will be getting to know.
My lord, I will ask my client. My
No,
lord,
I will ascertain, no, undoubtedly, I'll do that.
यही सर्किट पे कर लेते हैं क्या? Amount you deduct. After stopping.
I would like to see the figures.
My lord,
My lord, I will ask my client.
We'll get it, my lords, may have it.
But it would be better if they bring because I can give exact figure.
I'll certainly have the.
And my lord, in para, in before the tribunal also in para S, we have categorically said, I am ready to, and they filed their opposition, they did not deny this paragraph. Page number 40, inner page 10, paragraph number S.
Is that, my lords, drafting of lawyers cannot, this is a question of fact, evidence has to be like that. I will get the figure, my lord. My lord may have it day after tomorrow, even tomorrow, my lord. I'll try to get it, my lords.
Page 40, my lord. Paragraph number S.
Paragraph number?
Paragraph S, my lord. Page number 40, inner page 10 of the original application.
All right. Yes.
Reply will have to be seen.
Reply is there at page 71. Very nicely drafted reply. Let me see.
17th July 2020
That was the transfer order, my lord.
yes.
To
So
18th,
17th you work or on that day.
yes, 17th, up to 17th I work. 18th also I might have worked, my lord, when the order, I get the order while I was discharging the duties only.
All right. So from 18th of July, I want to know the period of absence.
80, my lord, that also I will get the exact date. It ought to be from 18th of July 2020 to 18th of January 2021. 21st of January 2021. But I will get it from my client, my lord.
The petitioner has since retired from service. Stop, she is aggrieved by the decision of the respondent authority
Page 65, my lord.
page 65, 66, whereby the intervening period with effect from 10th September 2020
Yes, my lord, that is the period. They are.
till her date of resumption on duty has been directed to be regularized by granting admissible leave. Paragraph. Learned advocate for the petitioner contends that the petitioner will be losing a substantial sum from her terminal benefit, as the petitioner will not be paid her leave allowance. Step next. The respondent authority is directed to file an affidavit giving details of the period of absence of the petitioner and the amount deducted from her pension, from her terminal benefit on account of her absence for the said period. Let such affidavit be prepared and served upon the learned advocate representing the petitioner by day after tomorrow.
If it is affidavit, then day after tomorrow. Otherwise, I can.
Day after tomorrow. List on 25th. Mr. Kumar, if you would like to file a reply to this to show that you at least went there to join or anything of that sort, then it will be.
My lord, I was working there only. They did not allow me. There is no question of joining. I was working in a place. They transfer me from there.
I have followed it.
Yes, my lord.
But
So
because this is the stand that they are taking, that you did not work.
I did not work. They did not allow me, my lord. That is what on para as I have said.
You could have lodged a complaint or a diary before the police to show that you went there, that they refused you to.
My lord, clients are not aware of.
I understand, but there is nothing on record. No, you can give it back. They'll file by way of affidavit.
Item 4, number 27 of 2020.
My lord, I am appearing for the petitioner.
Yes.
Here, my lord, these petitioners initially appointed under the Adim Janjati, my lord. And there they were working in the vessels, my lord, Laskar and all. So they worked for a considerable period under the said establishment. Subsequently, the establishment did not require the said vessel and the 7 numbers of those crew members in their establishment. As such, they deployed them to the Directorate of Shipping Service in the year 1994. Since then, these persons were working under the Directorate of Shipping Service and were posted in different part of the island, working in the vessels, plying by the Directorate of Shipping Service. Now, my lord, considering this, the administrator, he himself says, because the recruitment rule which was prevailing, there was no scope of absorption. The method of recruitment was 100% by direct recruitment or promotion. So these persons who were working in a different set of wing of the administration were working under them on transfer and posting. So if they want to insert them in their service, the only mode is to observe their service by means of absorption by the authorities. Now, my lord, for this, the files were mooted. Even the highest administrator under Article 239, he recommended, he is the authority competent to do it, and he recommended that their case has to be considered and they has to be observed under the Directorate of Shipping Service. But nothing was done, my lord. Ultimately, at the flag end of my career, from 1994 to 2014, I worked there. Thereafter, they transferred me to Port Management Board. And in the year 2017, I retired from service. I was raising this issue before the authorities. When this was not answered, I approached the tribunal. Tribunal directed them to dispose of the said representation. They disposed the representation by saying that in the recruitment rule, there is no provision for absorption. And therefore, we can't do it. Now, my lord, I have challenged that order before this honorable court. Because I can show the authority competent has recommended. Despite of that, that was not done. I served for more than 30 odd years under the said Directorate of Shipping Service, posted right from Campbell Bay, Mayabandar and everywhere, my lord.
And you were paid the salary according to any scale?
That was paid according to the scale.
According to the scale?
Yes.
And transfer was done according to the service policy?
Yes. Transfer was done. Transfer order, everything is there, my lord.
So everything is done in accordance with the rules that at the time of absorption, there is
They
no
say we
provision.
can't do it because under Article 309, the recruitment rule which prevail, There is no scope. There is, it ought to be amended or whatever may be, my lord. But I say, my lord, when the recommendation is right from the administrator who is the competent authority, I could have understand if a file is mooted by an incompetent authority or by a lower cadre persons, and ultimately it did not have the assent of the Lieutenant Governor, then absolutely it can't be. But here the Lieutenant Governor himself says to consider their service. There is recommendations are there, my lord. I will place from the record itself, my lord. So, my lord, where this person will go? Because in Adim,
What did the tribunal hold?
tribunal said, tribunal went by whatever statement they has made, and tribunal said since the recruitment rule did not have the provision, therefore it can't be done. But my consideration is, my lord, when the competent authority himself proposed, then what prevented them to amend it? My lord, kindly come to. My lord, this petitioner, I am just giving the dates, was appointed on 5th of August 1978 under the Adim Janjati as a Laskar.
Is he getting any terminal benefit?
No, because in Adim Janjati, my lord, the pension scheme and all is not there.
Then what does he get at the time of retirement? Any lump sum amount?
No, my lord,
Special
whatever
fees?
his own amount, what gratuity and all that
Gratuity
only.
he
Yes,
gets. Is there any scope for getting provident fund?
I think no, my lord. I will just ask, I have to ascertain this from Provident Fund and all. He
It's
has.
not there.
Despite of serving under the Director of Shipping Service, where the pension scheme is there, I was deprived of that. In para B, my lord, at page 42, the benefits I have said, my lord.
At this stage, is there any scope to entertain your writ petition?
No, my lord,
You have retired from service.
I have challenged the order before the tribunal. My lord, whatever issues are there to a government servant during his service career or after his service career ought to be filed before the tribunal.
No, that is all right.
Yes. So, my lord, now the benefits which I am entitled under the law, these pensionary benefits, that I have been.
Till you are absorbed, you are not entitled.
No, I am not entitled. I am not entitled.
So you retired in 2017.
My lord. Since then, I am before the court of law.
The original application number shows that.
No,
you
my lord,
filed in
it was second round of litigation.
Second round. First was
First round is there, my lord. First round,
consideration part.
consideration, my lord.
And then the rejection
Then
comes.
the rejection, my lord.
What will be your
I know
submission?
this AAJVS, which is the original employer of my learned senior's client, my lord. He was employed with AAJVS. Because the AAJVS was being disbanded, the administration as a welfare measure and to help out persons like the applicant before the CAT allowed him to work under the DSS on those terms. But
What are the terms?
my lords, on the terms on which he was serving the AAJVS.
Same terms. Were the terms same?
Let me just, my lords, ascertain that, my lords. My lords may see page number 63. This will give the entire background. This is a letter issued by the Directorate of Shipping Services to the Secretary Shipping. Now, my lords may see this refers to letter on the subject cited above. The executive, this is on the question of absorption itself. All the observations recorded by Special Secretary, proposal for has been pending. In this regard, it is to mention that vessel MV Milale of the AAJVS was placed under operational control of Directorate of Shipping Services. As the vessel was non-operational, the services of staff were not utilized by the department in the departmental vessels. Accordingly, with a letter dated 10th March 2000, the Executive Secretary AAJVS communicated decision of Honorable Lieutenant Governor for engaging the AAJVS staff in Directorate of Shipping Services till with the arrangement of pay and allowances of these staff being paid by AAJVS and overtime allowances
for utilizing staff services beyond working hours, if any, to be paid by the Directorate of Shipping Services. Consequent upon this communication, Directorate of Shipping Services started utilizing the service of the staff in the departmental vessels. In the meeting of General Body and Executive Council of AAJVS under the chairmanship of Honorable Lieutenant Governor, it was decided to transfer the services of staff of MV Milale to the Directorate of Shipping Services on permanent basis, including payment of salary and allowances. Consequent upon communication of such decision, the Directorate of Shipping Services informed the administration that AAJVS, being autonomous body, the staff working under them cannot be transferred to this directorate. Moreover, at the time of sending the reply on 23rd July 2003, there was no vacant post existing in the department and no budgetary provision was there for meeting the expenditure. The same communication, Executive Secretary was also requested to take up the matter of transfer of staff of Merchant MV Milale with the Port Management Board, as PMB was in need of trained manpower to sail its vessels. Further, in the meeting held in the Chamber of Special Secretary on 6 November 2003, it was decided that procedure for absorption of employees of MV Milale in the Directorate of Shipping Services would be examined in detail by AAJVS. No further action was taken up by the AAJVS on the issue as per records available. The department is not in receipt of any detailed procedure which was to be acted upon for the absorption of such staff. Rather, after a gap of almost 2 years, AAJVS sent the communication dated 31st March 2006 requesting therein to direct all 7 employees of AAJVS presently posted in different vessels of this department to report for duty in AAJVS. They were also stand relieved by the same communication. The matter was further represented by INTUC, wherein it was directed that services of these employees should not be transferred from Directorate of Shipping Service. In this backdrop, the note of Special Secretary TW, wherein it has been mentioned that on 18th April 2006 in meeting at Rajnivas, where Chief Secretary, Secretary Shipping and Secretary Personnel were also present, it was decided that since the official was trained only in the field of running the boats and their utility would be only in the Directorate of Shipping Services, they need to be absorbed in Directorate of Shipping Services as per relevant rules, relaxing hours as per the scheme or otherwise. In view of the above, it is submitted that at present the following staff of AAJVS is placed with the Directorate of Shipping Services. Now, this includes the serial number 1 is the petitioner here. The issue has been examined with reference to the strength, position, and present hours applicable among the particular post of afloat establishment. The details of the post as per recruitment rule are as follows. Now, my lords will see the remarks and the method of recruitment for 50% promotion. Use a Serang. Now, Serang 100% by promotion, serial number 1. Now, after that, my lords will see from the above, it is evident that with the present method of recruitment as given in recruitment rules, it may not be possible to absorb these staff in the directorate in permanent capacity, as the posts are to be filled up either by promotion or by direct recruitment. There is no method envisaged as transfer by deputation or absorption. Accordingly, the same has to be examined in consultation with personnel department and law department to find out suitable course of action by way of effecting necessary changes in recruitment rule if the decision of Lieutenant Governor is to be implemented. According, the same is forwarded.
My lord, pausing for a minute, my lord, this all my lord has read, and it says at the last portion, if the decision of the Honorable Lieutenant Governor is to be implemented. So, my lord, a decision was arrived.
Wait, no, my lord.
My lord.
My learned senior is no.
Yes.
Now, the point is, my lords, that if my lord sees the impugned order, the issue, my lords, is that who will amend the recruitment rules? The Lieutenant Governor is not the authority to amend the recruitment rules, my lords. Recruitment rules have to be amended from the central ministry in Delhi, my lords. But the fact of the matter is, my lords, that there is no scheme for absorption. So, in the absence of a scheme for absorption, I don't know what the CAT could have done better than what the CAT has done, because the CAT has asked them to consider the representation. They haven't made the representation. Perhaps they are saying the representation has already been rejected. But if there is a scope for reconsideration, my lords, the CAT has done what fairly the CAT could have done, my lords, in my humble submission.
No, CAT has dismissed my application.
No, my lords will see. Now, my lords may see, cannot be permanently.
This is the decision which was taken in 2006.
My lord.
What happened thereafter?
No, the representation was rejected.
No, not the representation. The document that you read out is dated 28th of July 2006.
Yes.
So it is from that point of time.
5th December 2019 is the impugned order, my lord, before the CAT.
No, my lord, the decision is 28th of July 2006.
Yes.
No, I understand.
Page 63 you read out is of 2006, where the authorities note that there is no provision for absorption in the recruitment rules.
My lord.
But thereafter,
5th December 2019, my lords may see the order which was challenged before the CAT. My lords may see. The detailed order has been passed. This is at page 120. 5th December 2019. My lords, we just have this order, my lord. This is issued by the Directorate of Shipping Services, page 120. Whereas Sri Jagdish Murthy Serang, initially in staff of Andaman Adim Janjati Vikas Samiti, presently working in Port Management Board. Sri Jagdish Murthy initially posted on board of the vessel. Now this is all history, my lords. I can read every line, or would my lords? Okay. Now, my lords may see, after let me at least reach where we last read, my lords, the last letter. Now, my lords will see 121. My lords will see bottom of the page. In response to the letter dated 16th June 2006, this directorate had sent a letter to the Assistant Secretary. This is a letter which I read, my lords. Yes. Assistant Secretary Shipping, dated 20th July 2006, stating the whole matter and submitted the inability to engage AAJVS staff in this department and sought for examination of the matter. The same was also intimated to AAJVS authorities with a letter such and such to revoke their relief order, and the services may be utilized as done earlier. In this connection, reminder also sent to administration to sort out the matter at the earliest. And whereas the audit report has been received from the Executive Secretary, it is understood that AAJVS has been registered as a society under Societies Registration Act with a view to prevent extinction of primitive tribal groups, Great Andamanese, Ongis, Shompen, Jaravas, and Sentinelese inhabiting Andaman and Nicobar Islands. The CNAG report in this report has stated expenditure in view of the above. A meeting was called in the Chamber of Secretary to discuss issues raised. Although after the meeting and as per directions of Chief Secretary, being Chairman of the Executive Council of AAJVS, 2 members of AAJVS have been posted at the Port Management Board. Accordingly, as per the decision, employees of AAJVS have been relieved from the duties with effect from 2014 in response to Executive Secretary letter with direction to report for duty to Port Management Board. Whereas Sri Jagdish Murthy in his letter dated 27 February 2019 has requested to consider his case for absorption to the post of Serang Master 2nd Class under Directorate of Shipping Services and to provide him all the benefits which are enjoyed by Serang Master 2nd Class on and from the date of his initial posting to the post of Serang on and from 1984. The Deputy Secretary Shipping informed that though your services were utilized by DSS, the pay and allowances were continuously paid by AAJVS. Moreover, based on your willingness, you have been permanently absorbed in PMB. And your request for absorption to the post of Serang Master 2nd Class in DSS cannot be acceded to. Whereas Sri Jagdish Murthy filed original application before CAT seeking a considered case for absorption in the post of Serang 2nd Class under Directorate of Shipping Services and to consider his representation. Whereas the Honorable CAT Kolkata bench, after hearing the above application, passed the order. We therefore dispose of the OA directing the 7th respondent to pass an appropriate order on representation submitted and forwarded to him by the Port Management Board a covering letter within a period of. Therefore, after consideration of overall facts, representation is not considered. So this is the decision. Now the point is, my lord, two things.
One minute. Page 122, the 3rd paragraph from the bottom, the 3rd line, it mentions that the services were utilized by DSS and pay and allowances continuously paid by AAJVS. Who paid the money?
Oh, AAJVS was paying, because as my lords will see, when initially I read, because the decision was taken to help them out, so they were being paid on the AAJVS was paying the same terms and salary except for overtime, which was paid by DSS.
So the remuneration of
Was being
salary
paid
was
by AAJVS. Yes.
by the original employer.
Yes, my lord.
Also, my lord, page 58 is the answer. The Lieutenant Governor says, you have to pay the pay and allowances, page 58.
You have to pay,
Yes.
and you paying.
No, the Lieutenant Governor is the administrative head. My lord, can you come to page
Where
58?
did you get the salary?
Page 58, I get from the DSS. How can I, serving here, I will get the salary from Adim Janjati?
This is what was striking as to who was paying. It is the DSS.
Yes, my lord. My lord, in page 58, if my lord comes to their own communication to the Directorate of Shipping, it says, the Executive Council meeting of ASJS held on 20th February 2001, the Honorable Lieutenant Governor, Andaman Nicobar Island, ordered the transfer of the service of staff of MV Milali to the Directorate of Shipping Service, and pay and allowances of the staff may be met by the Directorate of Shipping Service. The service of the following staff, the name of the applicant appear at serial number 1. There is an order of the administration.
No, this
How
is
they can
this is a letter from that autonomous body. Kindly see the letter of the government at page 63. Page 63 is very clear. It's a question of fact. It is not who had directed what. My lords may see page 63. It is clearly mentioned here, my lords.
My lords, may please have the third paragraph. Consequent upon this communication, this refers to that earlier letter also. Directorate of Shipping Services started utilizing the services of these staff in departmental vessels. In the meeting of General Body and Executive Council under chairmanship of Lieutenant Governor, it was decided to transfer the services staff to the Directorate of Shipping Services on a permanent basis, including payment of salary and allowances. Consequent upon communication of such decision, Directorate of Shipping Services informed administration that AHAVS being autonomous, but this is the letter which I had shown, which my learned senior referred to. Being the autonomous body, the staff working under them could not be transferred to Directorate. Moreover, at the time of reply, there was no vacant post. In the same vacant post, there was no provision for expenditure. In the same communication was also requested to take up the matter of staff of such and such. Further, in meeting of the Chamber of Special Secretary, now my lord may just see the paragraph before that. My apologies. In this regard, it is to mention that vessel MV Milalia was placed under operational control as the vessel was non-operational, services was not utilized. Accordingly, with a letter dated 10 March, Executive Secretary communicated decision of Lieutenant Governor for engaging the AHAVS staff with the arrangement of pay and allowances of these staff being paid by AHAVS and overtime allowances being paid by the Directorate of Shipping Services. I can ascertain, factually, I can ascertain whether who was, if there is any doubt on that, my lords, of course, I can ascertain that. And also, my lords.
Yes, you continue, let us see.
Also, my lords, page 122 says that he was absorbed in the PMB. My lords may see page 122.
122.
It says, moreover, the third last para,
Yes.
third last recital, whereas the Deputy Secretary 26 June 2019 informed that though your services were utilized by the DSS, the pay and allowances, this is clear, were continuously paid by AHAVS. Moreover, based on your willingness, you have been permanently absorbed in PMB. That is the Port Management Board. It's another government body. So, my lords, he has been permanently absorbed in the PMB. The letter says so. Whether they are factually disputing this, my lords, because there is a letter of a government authority which is saying that they have been absorbed in the PMB. So how can they be again absorbed in the DSS?
Where is the scope for absorption, this Mr. Binu Kumar?
My lord,
I don't find any scope for absorption.
my lord, I
Show
say that,
something there, apart from a recommendation from the Lieutenant Governor, there is nothing to show. The recruitment rule does not permit.
yes,
The moment you were transferred from that vessel to the DSS or the PMB,
DSS, my lord,
DSS,
my lord.
Your posting, your engagement, anything does not speak of absorption in regular service.
No, it was not, I was never absorbed. I say that, my lord, it was a
Seek
transfer.
absorption.
I seek absorption.
Yes.
I say, my lord, it was a transfer and posting in 1994.
Where is the provision for transfer posting from a private vessel to
No,
the
not a private
DSS?
vessel, my lord.
DSS is not, no, the AAJVS.
Chief Secretary is the chairman. It is an autonomous body, society of the Hon'ble administration.
Like from society to DSS.
Yes.
Where is the provision?
My lord, they are utilizing this service,
Utilizing a service and made payment.
make payment.
It's like a contractual employee.
No, my lord, I was a regular employee.
I understand.
My lord.
It may be akin to a contractual employee and a regular employee, or a temporary employee and a regular employee. The service benefits are absolutely different.
No, my lord, here it's a society which is under the pervasive control of the Andaman Nicobar administration.
The two sets of organizations where you are serving are completely different.
No, but are under the same umbrella, my lord.
Same umbrella.
Yes.
Maybe, but then the recruitment rules are different. The service benefits are
My
different.
lord, the case, they have not made out a case that I did not qualify in terms of for this
You
particular
say
post.
the qualification.
Yes,
But then the recruitment rule, the avenue for recruitment is different.
different, my lord.
In
Only the-
Chanang's,
Yes,
it is only through promotion.
my lord.
You did not appear in any examination or anything of that sort.
No, I cannot,
Compete with others.
because I don't have the regular service in DSS.
Yes. So that
In the
is the
field,
position.
I don't have. But my lord, my case is, my lord, if my lord sees, my case is, my lord,
No, I can very well understand your case. You were working in JVS for so many years from 94.
94 to 2014, I worked under the Directorate of Shipping Service for
Yes.
30 years, my lord. And I was posted in different
Places.
places by the Directorate of Shipping Service. I did not, all pervasive control was under the Directorate of Shipping Service. Adin Janjati did not have any control over me.
Everything said and done,
Yes,
the basic thing, the route of your recruitment
yes,
was not proper in the DSS. You were simply absorbed or
transferred, my lord.
Transferred.
Transferred.
Made to what?
My lord, a government servant, if I am transferred from one department to other department, I am not at fault. I can show the transfer order,
Suppose,
my lord,
assuming you are not transferred and the place where you are working JVS
my lord.
just shut down, what would have happened? You would have.
I
left
would
your
not be in
job.
service, my lord. Yes, yes.
So at
But
least,
my lord, now the scenario is otherwise, my lord. Now, my lord, the scenario is otherwise. I worked under them for 30 years. And my lord, they recognize me. They say that, yes, you have worked 30 years. The highest body said, yes, you observe him by amending the recruitment rule. It is their recommendation.
the only recommendation will not do.
Only recommendation will not do.
Be there. Where is that law? And the Lieutenant Governor,
Law is there, my lord. Under Rule 5 of the notified recruitment rule, which was prevailing, the recruitment, the Lieutenant Governor can very well amend the recruitment rule or
is it possible
my lord,
for recruitment rules to be?
it was not a direct recruitment. Can you have a note of this? If it's a direct recruitment, that would have been a different, altogether different cause of action, my lord. Here it's a promotion. Admittedly, I am working from last 30 years. I am entitled for promotion only because I have been transferred from one department of the one wing of the administration to other wing. I am not getting that
That
benefit.
is for your survival.
No, my lord. But
Had you not been transferred, you would not have survived in service.
my lord, if my lord sees page number 58, my lord. Once, my lord, kindly see page 58, my lord.
Yes.
My lord, it says the Executive Council meeting of so and so on 20th February 2001. The Honorable Lieutenant Governor, Andaman Nicobar Island, ordered the transfer of the service of staff of MV Milali to the Directorate of Shipping Service, and pay and allowances of the staff will be met by the Directorate of Shipping Service. The service of the following staffs are already under your control as per the decision taken by the Honorable Lieutenant Governor. Now, my lord, now the letter which my learned friend has read at page 63, my lord. I am just reading the operative portion only. My lord, kindly come to page 65.
Yes.
63, my lord. In page 64, if my lord once come to page 64, second paragraph. It says, in this backdrop, the note of Special Secretary Tribal Welfare, wherein it has been mentioned that on 18th of April 2006, in a meeting at Raj Nivas, where Chief Secretary, Secretary Shipping, and Secretary Personnel were also present, it was decided that since the officials was trained only in the field of running of the boat, and their speciality, their utility would be only in the Directorate of Shipping Service, they need to be observed in this Department of Shipping Service as per relevant rule, relaxing recruitment rule as per the scheme or otherwise. Now, my lord, they are conscious of the fact how it can be done.
No, but then thereafter no scheme was formulated.
No scheme, or my lord, they say as per the relevant rules or relaxing the relevant rules. Now, my lord, kindly turn to next page. It says, from the above table, it is evident that with the present method of recruitment as given in recruitment rule, it may not be possible to observe these staffs in the directorate in permanent capacity, as the posts are to be filled up either by promotion or by direct recruitment. There is no method envisaged as transfer in deputation or absorption. Accordingly, the same has to be examined in consultation with personnel department and law department to find out the suitable course of action by way of effecting necessary change in the recruitment rule or otherwise, if the decision of the Honorable Lieutenant Governor is to be implemented. What I want,
Well, in that case, from 2006, it is pending till date.
my lord,
Nothing has matured.
my lord,
So no relief can be granted to you.
only one thing, what, my lord,
Mr. Vinu Kumar, we have given a lot of time to you.
no, only one thing, my lord, decision was arrived from the Lieutenant Governor, my lord.
Just one thing I wanted to point out, my lords, because it had fallen from the court that what are the benefits that he's getting.
Yes.
In a reply before the CAT, my lords, may just have page 131. It's my duty to the court to point this out. The my lords, may see para 8. The respondent authorities, however, submit the second line after decommissioning of page 131. Vessel, the crewmen, including applicant, were recruited only for manning, were sitting idle and could lose their job. A decision was taken that services may be deployed under disposal of respondent number 7, Directorate of Shipping Services, and respondent number 7 shall continue to disburse the pay and allowance. Since employees are AHAVS are covered under Employee Provident Fund Scheme, contribution of the employee applicant was continued to be subscribed in his retirement from AHAVS. Now, my lord,
So you are getting the provident
so
fund.
now this is it's like akin to a private employment, my lords, because you're a private employment, you cannot say he wants, I can understand as an employee, he wants the benefit of pensionary benefit, my lords, but that, my lords, cannot be a legal right.
Supporting rule has to
My
be
lord.
there. Please come. The petitioner, presently a retired employee, seeks absorption in the Directorate of Shipping Services. Stop. The case of the petitioner is that he was initially serving in the AAJVS. Stop. His service was thereafter transferred to the Directorate of Shipping Service in the year 2001.
No, my lord, 94.
Actually, 1994. And his pay and allowances was met by the original employer, that is AAJVS. Stop. The prayer of the petitioner seeking absorption was taken up for consideration. And by a communication dated 28th July 2006 by the director within bracket administration, Directorate of Shipping Services, addressed to the assistant secretary within bracket shipping, ANN administration. It was communicated that the present method of recruitment as given in the recruitment rules may not be possible to absorb the petitioner in the directorate in permanent capacity, as the posts are to be filled up either by promotion or by direct recruitment. Stop. There was no method envisaged as transfer on deputation or absorption. Stop. The same was to be examined in consultation with the personnel department and law department to find out a suitable course of action by way of effecting necessary changes in the recruitment rules or otherwise, comma, if the decision of the Honorable Lieutenant Governor is to be implemented. Stop. The matter was forwarded for necessary action. Stop. Paragraph. It appears that till date, there has been no scheme implemented for absorption of the staff of AAJVS. Stop. The petitioner on his retirement is covered under the Employee Provident Fund Scheme, and the contribution of the petitioner was continued to be subscribed till his retirement from AAJVS. Stop. Next. After hearing both the parties in details, it appears that the prayer of the petitioner seeking absorption cannot be allowed in the absence of a regular scheme or an amendment in the recruitment rules. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Line.
Number 5. WPCC 28 of 2023.
My lord, I am appearing for the applicant, my lord. He is a very unfortunate applicant, my lord, because he was entangled in a criminal case in the year 2013, my lord. On 28th of October 2013, he was entangled in a criminal case, allegation of bribe of 5,000 rupees. He is a sub-inspector of police. Now, my lord, after that, my lord, he was dismissed from service. A disciplinary proceeding was initiated, he was dismissed from service. In the criminal trial, he was acquitted from all the charges. Now, my lord, I approached the tribunal challenging the dismissal order on several grounds, and on 12th of April 2021, the tribunal arrived to a definite finding saying that both the order cannot be sustained. The order of the disciplinary authority and the order of the appellate authority was set aside. Set aside, and the matter was remanded back to the disciplinary authority for passing orders. My lord knows very well, my lord, only in rarest cases, the court enjoys the jurisdiction whereby the court set aside the order and thereafter exonerate him from charge, because exoneration or giving a punishment is the domain of the disciplinary authority. And therefore, the court has remanded back the matter and categorically stated, kindly have a note of this, that the independent witnesses were not examined. Kindly have a note of this and pass order. Now, my lord, once the tribunal set aside both the order, I approached this court. I said, when the tribunal has set aside both the order, then there is no requirement to send back the matter before the disciplinary authority. But this court said, since the disciplinary authority enjoys the power to pass an order, either to exonerate or to give punishment or whatever, so there is no wrong in the order, and they will pass the order in terms of the order passed by the tribunal, more specifically in paragraph number 14. Now, my lord, the disciplinary authority, instead of passing the order, my lord, exceeded its jurisdiction and thereafter once again examined the witnesses. One after another, my lord, orders were passed. During the night, 11 p.m., I will be receiving a notice that tomorrow the matter is there. I immediately approached the court.
Wasn't there an inquiry officer?
No, my lord, inquiry was concluded.
Then where is the scope of re-examining the witnesses?
That's what I am saying, my lord. So even the CAT categorically said, no, my lord, I will just place the order of the tribunal.
No, 1 minute. Thereafter, what happened?
Thereafter, my lord, after the order of the tribunal, this court said immediately reinstate him service and pay the subsistence allowance. And thereafter, they reinstated him in service, paid the subsistence and allowances. But they pursued with the disciplinary authority, pursued with the inquiry which was already culminated. And the court never passed an order saying that you once again examine the witnesses and thereafter arrived to a finding. This was not the decision of the court. And they have accepted that order of 12th April 2021 by the tribunal. Now, my lord, in absolute misuse of power, one after another steps were taken, and once again I was dismissed from service. My lord, if my lord once come to the order of the tribunal,
that is the cause of action for filing the original application.
Original application before the tribunal, yes.
Yeah.
And the tribunal said, no, it was, they have the liberty to do that. Now, my lord, first, my lord, come to that judgment first, my lord. It starts from page 318. And relevant would be, my lord.
This matter will take some time, I think.
My lord, it will take time. But my lord, once my lord read this judgment, thereafter, if my lord sees that all the aspect has to be taken, then I will not. But once only
It has to be taken. Because otherwise it cannot be decided.
My lord.
We will transfer it in the next circuit because we do hardly have time.
My lord.
And I am already,
But my lord, it's unnecessarily a person because of the misuse of power of the authority. They interpret the order in their own way. If my lord sees only paragraph 14, it's a clear order of the court. I was defending him. The court said to me, Mr. Kumar, you go there, they have to pass the order only on the basis of this. What prejudice will be caused? But if my lord sees para 14, it's categorically clear, my lord. This,
no, let it go before the next circuit. It will
Well.
take time.
My submission would have been that we have actually complied with the order. That's
Both
what the
orders.
cat says.
I have followed it. Let the matter be placed before the next available circuit.
Item number 6, WPCP 29 of 2023.
my lord, this matter just not today because I am challenging the interim order, rejection of my interim prayer by the tribunal, just not today, my lord.
Before the next.
No, my lord.
Why not?
No, my lord. It's a very short matter. I will just rely two judgments, my lord.
No, next.
Very
circuit.
short issue, my lord.
Next circuit. Let the matter appear before the next circuit.
My lord.
Mr. Kumar's energy is enviable and even at his age, inspiration for all of us.
Is that a
Why do you
His
mean to
age?
say that he is aging?
No, not at all. You can mean it like that, but with energy force with which, and I've seen him that he does high court in the when cat, there was a time when cat circuit was also coming. So with the same energy, he would do the matters in the high court. Then from 3 o'clock with the same energy, he would put in the cat. Sometimes, we would wonder what is it that he eats.
Get hold of his diet chart.
Item number 7.
May it please your lordship.
For the respondent.
Respondent,
Respondent.
which respondent?
Madam, this is a habeas corpus matter.
Yes,
Report was asked by this court. Last occasion, report has been filed by the
Yes,
respondent number
yes.
2 and the 4.
Hmm.
Lordship, I'm applying for the response number 3, directorate supervisor.
Except 3 I am.
yes, Mr.
First and foremost, my lord, on that occasion, when the matter was heard on Monday, I had made a statement that this report is wonderful because it is showing the very definitions of what we say is a perverse order. First of all, may I just take your lordships through this? I have attempted to crystallize the procedures for a child in need of care and protection as opposed to a child in conflict with law in the form of a flowchart. This is what is derived from the Juvenile Justice Act of 2015, the new amended act, as well as the 2017 rules and regulations that are made by the Andaman's administration. Now, first and foremost, if your lordship sees, information comes to the Child Welfare Committee. It comes in the form of information from different sources under Section 30 of the Act. The child would be produced before the CWC, that is in accordance with Section 31. Then there are procedures for that. The CWC would take cognizance and receive the child, that is under Section 36(1). Now, at this point of time, the procedure bifurcates into two parts. On one side, the CWC is enjoined by law to conduct an inquiry. That inquiry is the entire process which has to take a maximum of 4 months. This inquiry will find out what is the background of the case, why the child needs to be taken care of, what are the other alternatives, parents, guardians, fit persons, institutions, all of this will be looked at. That inquiry is a detailed proceeding mandated under law. Now, in the meantime, the CWC has to also conduct the social investigation. Now, this social investigation takes 15 days, maximum period of time. And that social investigation will come back and say, what is the situation as to the interim period as of now? Now, a child in need of care and protection can be someone who is abandoned, someone who is destitute, has no parents, has no family, needs adoption. There's a variety of situations that can come. So for this, the CWC is empowered to pass certain interim orders. The interim orders come under section 36(1) of the Act. This is the other side. And along with this, the rules that are framed by the Andaman and Nicobar administration provide for those same interim orders to be passed, by which the child would be placed in a particular situation where the child's interest is taken care of and the child is safe. Now, the 2 or 3 things that come out from this report. First of all, I'm ignoring the report of the District Child Protection Officer because it's identical. Paragraphs 1 to 5 are basically copies. It's quite ironic that the chairperson of the CWC has simply copied this or someone has copied this. Either way, the language, full stop, question mark, comma is identical. So I'm keeping this aside. The only thing I'm looking at from the perspective of the District Child Protection Officer's report is paragraph 6, which is saying that it is submitted that keeping in view the safety of the child, especially cases that are registered under POCSO Act. So cases in general, the victim children is refrained from releasing from childcare institutions as they are likely to be influenced by vested interested people and for abundant precautions until the evidence is over. This is an absolutely ridiculous statement, sorry to say. In all cases, a blanket general observation like this cannot be made because the Act mandates on a case-to-case basis where the child is produced. The child is not produced as a matter of course. In all POCSO cases, the victim is not produced as a matter of course before CWC, only in cases where it may be deemed to be necessary. In such cases, there has to be an independent inquiry.
We are here with a habeas corpus petition.
Yes,
The scope of the petition is not so large.
my lord,
So why will we go into all these legal lines?
for the simple reason that when your lordship looks at the reports, the procedures that are required to detain me have not been followed.
Do you think that the child is detained over there?
This is amounting to a detention where the child has expressed her wishes, her own wishes, which are being ignored. If you are to deny me that, man, this is a judgment of our honorable court. Every single high court in this country, and regrettably not the Supreme Court, has passed orders in such situations where where girls are being detained in Nari Niketans. We have an order of our own high court which says you cannot do this against her wishes. You have to go as per the procedure of law. And in this situation,
The child is a few months away from.
this fell from your lordships that day, that wait for a few months.
Yes.
I have waited for a year. This child's academic career has been destroyed. She passed class 10. She had to do class 11 while she was in the home. She's failed. She has stopped studying altogether. She has no family life. If you are a victim of a crime, a violent crime, there is no reason the system and society is to victimize you further by destroying the rest of your life.
Who is going to take care of the child?
Well, the mother is undertaking to do that.
Has married somebody else.
No, absolutely not, my lord. The mother has.
The report says.
The report says that paragraph 5, the mother approached to take the child on leave. The request was rejected. Let us see where is that order and where is the inquiry.
No, the chairperson's report, you please see.
I'm at the
Paragraph
chairperson's
number
report, my lord.
Paragraph number 7, the
My
very
lord.
first line in the second page.
My lord,
The parents are separated. The mother is living in a second marriage.
very good. How is this prejudicial to the interest of the child?
It may be.
My lord, with the greatest of
And
respect.
another thing, paragraph number 10.
My
Please
lord,
come.
my lord,
Second
again,
line, the case is a very high profile
with the
case.
greatest of
The
respect, my
accused
lord.
being very influential.
With the greatest of respect, that's why we have witness protection programs. There are systems and andaments which are used for other witnesses. There is no reason to take away liberty. Liberty is a totally different paradigm over here. The child who is a borderline case, it's not that she's a very young child, 3 years, 5 years, 6 years needing care. This child is almost a major. She will be a major in a few more months. It's a different issue. Today, if the child says, I want to leave here, I want to go to my mother, it is the duty of the state to ensure that she can stay with the mother and still be safe. The safety of the child is what is paramount, not the considerations they have given. The consideration they have given is not even age. Man, kindly consider paragraph 6 in the DCPO's report, and here paragraph 10 is that we'll keep you till your examination is over. The only consideration which has been adopted by the CWC and the DCPO which is exactly what happens when a quasi-judicial authority is being administered by an executive authority, is we are not interested in your welfare. We are interested in getting your evidence. Throughout the tenor of this language.
As well as a welfare.
My lord, I'm sorry, with the greatest of respect, kindly see, this is why I asked for the file of the CWC to be called for. Kindly see the inquiry report. What shows? They have done 2 inquiries, they say. The first is a report that is submitted on the 2nd of June when she was first produced. At that point of time, they asked for a report. On the 2nd of June itself, a sub-inspector Nandini gives this report. That is one thing. That's not the inquiry. At best, we can say this is a social investigation. The second report is given after we have preferred this and served a copy of the petition on the 18th of August 2023.
Just wait for a few more months, please come.
My lord, kindly consider one thing. If this child is kept like this is a absolutely blatant violation of personal liberty. You can keep the child, but you have to do so in accordance with the procedure established by law.
You will be surprised to note that in the course of our official duty over here,
My lord,
we had the occasion to visit
my
the
lord,
place where the child is presently kept.
my lord,
Other places also.
my lord,
And we have interacted with the inmates
my lord,
of that place.
my lord.
There are senior citizens, children like that of the victim girl over here.
Did your lordships have the opportunity to interact with this girl?
We did not identify her because that
I
was not required,
Lordship,
right? Overall, we have seen,
my lord,
because we were not there with this matter. We just went there for our visits, the official
lord.
visits that we had.
Understood.
And we did not find anything. There was no complaint from any of the children who were there. They appeared to be extremely happy with their friends, in the company of their friends.
my
The
lord.
place was very good. And so we are not convinced with any of your submission
Fine.
that the child has been illegally detained over there.
Let me just make 2 submissions. Since your lordship has said this, my lord, with great humility, I have had some experience with the remand homes and with these institutions myself. 2018, when this home was functional, an FIR is lodged on the 23rd of March 2018 under section 75 of the Juvenile Justice Act by one of the inmates, Ruma Roy. This FIR is lodged against the chairperson and members of the CWC and staff of the home. It transpires from that at that time, one child committed suicide. The members of the CWC and staff were accused of abuse of various sorts, physical and mental. An FIR was registered. A trial is still going on. One girl committed suicide. 2 more were rescued from the home. This happened in 2018. In 2020, when COVID started, this honorable court was taking up a matter, WPA 5327, at the principal bench,
Yes.
because the Chief Justice had constituted that. I believe it was Justice Standen and Justice Sen, probably.
Yes.
At that point of time, reports were called for from all the different districts. From here as well, reports were called for. The district judge submitted reports. On at least 4 occasions over video conference, the Secretary Health, Secretary Social Welfare were directed to appear. A vast set of deficiencies were recorded and various orders were passed to set things in order. These orders continued to be passed up till probably 2021. After that, my lord, the matter has remained pending in the principal bench. Here, no further orders have been passed. Even at that point of time, hearings by the CWC, JJBs were not going on. Reports were sent to the High Court on the administrative side. Ultimately, I think the filling up of vacancies started in May 2023 this year, when advertisements came out for filling up all the posts of chairperson, child welfare committees in all the districts and Andamans. So right now, things may be working fine and the situation may be no complaints. But definitely, it has not been the situation that one can say there is no problem.
So right
This-
now, let us wait.
No, my
Let
lord,
the
my lord,
child-
may I just say this? May I just say this? The issue here is not about the conditions of the home. I have said that the child is not happy at the home. I have said the child is facing psychological difficulties, academic problems. I've said all of this. She said so herself in her representation. On instruction, I put it in the petition. But what is more important is today, if the child says, I do not wish to stay, that wish has to be honored.
No, but then we are not convinced that the child has said something like this.
My lord, if that is a situation, then in that case, as I submitted before this court at the beginning on the first day, let the girl be produced and examined by this court.
Wait
Hello,
for someone.
There is no reason for us to assume
That will
something.
be a torture upon the child. She appeared to be all the children, not she, because we did not identify anybody. They all appeared to be in very good companion with each other.
My
So
lord,
wait for a few months,
My lord, may I say this?
let her attain her majority, and
My lord,
thereafter she take an
my lord,
independent decision.
may I just say this?
As of now, nothing.
Number one, your lordship has seen representations that have been made.
Take lordship for the response. Lordship.
Just one
We hear you. We hear you.
My lords have seen the letters that are written by the child. We have been given these letters by the mother who has categorically stated, I asked her to affirm this on affidavit so that I'm not making reckless statements. She has affirmed on affidavit that this child is in severe psychological distress.
No, we don't think so. Yes, what is your submission?
After registration of the POCSO case, the girl is the victim of the POCSO case. Section 363, that is kidnapping also there. Lordship, kindly see the report, Lordship. Last meeting on 1st September 2020, mother meet with the child. Thereafter, Lordship, no representation has been made by the mother. What happened actually practically, Lordship? The accused is the influential person. Who is the Gram Panchayat Pradhan, where the victim residing. First. Second part, the parents of the victim, the mother is residing with another man. No touch with the father, no touch with the husband. So there are some environment, can you see the environment of the parents' house owner? For the welfare of the child, the committee had decided. Moreover, when the case was registered, the victim was produced before the court below for recording the statement. Till that the victim's mother, neither father or mother, came before this court, not claimed that we won the custody of the child. Then committee decided, the victim was sent to the committee concerned, the child, that Nikatan, for welfare of the child. 7 times the victim was made by the mother. What happened after 1st September 2022, Lakshmi, the mother of the victim, with the influence of the accused, tried to influence the victim, Lordship, because the next date is, I think, 19th September for framing of charge. 19th September framing of charge. Now stage for commencing a trial, only for indirectly influence the victim. It is a play role by the accused person because mother is not residing with the father. She is residing with another man. It is the situation of the case, Lordship. So kindly see the report. Kindly see the report. On the official report has been submitted for welfare of the children. And the consent of minor girl is not a consent. Why she has to come and say, I willing to reside from where? Kindly see the report, Your Honor. Second part, habeas corpus, how? Everybody known the victim, where the victim is residing. It is not like that the victim is missing or somewhere to produce passing habeas corpus. So these twofold grounds, this writ petition is liable to be rejected, Lordship.
My lord, may I just make two very humble statements? Lordship has given me a lot of time, just two statements. Number one is, if Mr. Kamakar is saying that this witness has been threatened, that the mother is trying to influence, I would not at all open my mouth beyond that. But if that is so, the state would have taken some steps. 195A, witness protection, all these steps were there. Nothing has been done. The mother's representations have been made. It's only when we give a demand of justice and file this habeas corpus that this entire thing starts. Till now, no one has been aware of anything. Number one. Number two, again, the evidence would be taken. I have no doubt about it. The evidence will happen. The trial will happen. The issue here is again the state is expressing the money for the trial, not for the girl. I would beseech your lordship, A, kindly interview the girl and see what she has to say, not in the settings of the home where your lordships are making an official visit. Let her come here as a petitioner and say what she wants. There is absolutely no difficulty. This has been done on numerous occasions and it is still done. Your lordship can get an accurate picture free from any influence, whether it's influence from the mother or influence from the state and the home authorities. And then your lordships arrive at a conclusion. I may not even press after that. If your lordships feel, let us stay in the home, let certain directions be passed. I will not push this court any further. But kindly first take the girls. Girl has to stay into consideration. That's all I'm asking.
Please come. This is a writ petition for habeas corpus filed at the instance of the mother of a victim girl. Stop.
The victim girl is a victim, represented to the mother. Because she has said.
What did I say? filed by the victim girl, represented by her mother. There is no signature in the Wakalatnama also of the victim.
Father cannot execute a wakalat.
Yes, but then it is,
The mother has come to court. I have checked her Aadhaar card. My learned friend has interviewed her before we did anything. We
Yes.
checked all that. We checked the Aadhaar card and she signed
Actually.
in front of us.
the petitioner is approximately 17 years, 8 months,
8 months.
approximately 17 years, 7 or 8 months. Stop. She is presently in the Balika Niketan. Stop. Paragraph. The learned advocate for the petitioner relies upon a letter allegedly written by the victim child, mentioning that she intends to go back to her mother and reside with her. She has also mentioned that she was unable to concentrate on her studies and has been forced to stay there based on some misconfusion. Stop. Next paragraph. It appears from the documents annexed to the writ petition and the submission made on behalf of the parties that the petitioner is a victim at the instance of one of her uncles. Stop. A proceeding under POXO is pending before the court below. POXO Act is pending before the court below. Stop. Next. The petitioner is at the said shelter home from when? 2nd June 2022. Stop. The paragraph submission has been made that the petitioner should be handed over to the custody of her mother, as she has herself expressed her intention to go back to her mother. Paragraph. A report has been filed by the Chairperson, Child Welfare Committee, South Andaman, dated 18th August 2023, wherein it has been mentioned that the child was provided with safe shelter at Balika Niketan by order of the Child Welfare Committee. Stop. On 14th June 2022, the father of the child, along with relatives, approached the committee to meet her. Stop. The father was allowed to meet the child. Stop. Paragraph. On 1st September 2022, the mother of the victim child approached the committee to take the child on leave, but the request was rejected by the committee. Stop. The mother was, however, permitted to meet the child. Stop. The mother met the child for nearly 7 occasions. Stop. Paragraph. The report mentions that the parents of the child are separated and the mother is living in a second marriage. Stop. the case is a high profile case and the accused is very influential, being the pradhan of the area. Stop. The mother, at the influence of the accused, is trying to release the child from the welfare home. Stop. The committee has made sure that all the facilities are provided to the child for her psychological well-being and academic growth. Stop. A team counselor and social worker from the committee are in continuous touch with the girl, and a full-time counselor is already present in the shelter home. Stop. Next paragraph. Upon hearing the parties and upon perusal of the report filed by the Child Welfare Committee, Chairperson, Child Welfare Committee, we are not convinced with the submission made on behalf of the petitioner that she is required to be released, from the welfare home at this stage. Paragraph. The child will attain majority within a couple of months. She will be entitled to take her own decision on attaining majority. Stop. At this stage, issuance of a writ of habeas corpus is not warranted in the facts and circumstances of the present case. Stop. In view of the above, no relief. No relief can be granted to the writ petitioner. The writ petition fails and is hereby dismissed. Stop. The chairperson of the Child Welfare Committee is directed to ensure that all protection and measures are taken for the psychological well-being and academic growth of the child is taken care of.
I'm grateful for that. Can you mention that one or two more things? Under Rule 74 of the Juvenile Justice Rule 74(1), every child in childcare institution may be permitted to have one meeting in a week with his relatives. Your permits that visitation, and if
has anybody stopped you to visit?
Yes, they've said only once in I think nearly 7 times they've been allowed.
No, not allowed. Nobody went there to visit.
When I've been going, I have made a specific statement in my petition. The mother has been going, she's not been allowed. This specific statement.
No, this is Sunday. Yes, every Sunday. Let her go. No further.
My God will kindly clarify that. That will.
What is the requirement of clarification? A pressure will be put in that case.
The Kormakar is afraid that there will be some influence being done. Let the mother at least meet in the presence of a social worker or something. Let someone supervise the meeting. I'm trying to be as fair as I can. Let the supervisor, the person in charge, whoever is there, let them be present, but let the mother at least meet. But specifically, the instruction has been given the mother is not being allowed.
But liberty is there already. Every Sunday, the parents
are there in the rules.
Learned advocate representing the respondent authorities has submitted before this court that the mother of the child is allowed to meet the child every Sunday in the presence of the
requested or by the mother of the.
No, request is different, but then in usual course, the mother of the child is permitted to meet the child in usual course every Sunday in the presence of the member of the
Very great.
Malika Niketan.
Very good. I'm very pushing my luck.
One of the third prayer is all the documents of the Child Welfare Committee, these orders that have been passed are actually subject matter of challenge. You can challenge them in review, revision before the child court and other authorities under the act. Well, there is no mechanism for supply of certified copies or giving us copies.
Why RTI?
Why RTI? This is a quasi-judicial proceeding. If I ask for copies of the orders, the mother is entitled, the father is entitled to have access to those orders. We have not been given any documents, even on being asked.
Well, that is not a matter of the habeas corpus, at least.
To be honest, my lord, with the greatest of respect and Mr. Kormakar's fairness, may I say this? The minute this petition came, the case came, my fear was the first thing that Mr. Kormakar said, that there is something more perhaps. That a child would be attempted to be influenced, maybe the parents have been paid off. My lord, I had that fear, which is why we were extra careful in checking every detail of the mothers before we filed. But at the same time, my lord, that is why we are in a situation where
See, the ground level reality is something else. The mother portraying a different picture.
The mother is giving a picture which we checked the documents. She said it on.
No, only documentary evidence will not do. We have seen it with our own eyes.
That is why the minute you also said that, I have not pushed beyond that point. I'm grateful.
Item number 8. 45 of Contractual.
Service wire. Retire was. I don't know. Director of the service. You want us to?
Lord, I am for the petitioner. my lord.
Because I have not received a copy of the petition, my
I
lord.
saw
Also,
it from the department.
I have not
Yet
received
to
it.
receive
I
it.
usually appear for this department. That's why, my lord, I can take instruction. Otherwise, I can come back. It can
Come back tomorrow, my lord. I
Let
am
a
praying
copy
for
be
interim
served
order.
upon us,
Education department.
My lord.
my lord. If copy is
But then I see there are private respondents also.
But my lord, I have also made private respondents, my lord, but they have not accrued any right.
Maybe, but since
I-
the
I-
neighboring parties, they
My lord,
are
yes. I dispatched them.
not, service is not ready.
central government will also first respondent.
My lord, urgency is there, my lord. Why I am praying? I filed the original application before the learned tribunal. Learned tribunal rejected my interim order. Against that, I filed this application. There is a direction upon them to file the affidavit. They are not filing the affidavit before the tribunal also.
This
No.
we will direct.
My lord, and another point is that in the middle of the, during pendency of the application, if the recruitment process is completed, my original application will become infructuous.
Why
This-
to approach the tribunal for necessary orders, interim orders?
Well, that was refused against
So
that.
what is the prayer that you made before the tribunal?
My lord, primary school resource teacher, my lord, advertisement was made. Resource teacher means the teachers meant for educating the handicapped students. The central government, the Rehabilitation Council of India is there under the Ministry of Social Welfare. In terms of their recruitment rules, their directions, the recruitment is to be made. The administration is going beyond the directions of Rehabilitation Council of India and published some recruitment rules. We applied for under RTI some recruitment rule, provided the recruitment rule which is prevailing in the time. They supplied us a recruitment rule which is of 1998. And they published advertisement by saying that some other recruitment rule. That recruitment we do not possess. And the Rehabilitation Council of India recruitment is totally different. In the guidelines, they are saying that we have to follow the Rehabilitation Council of India's directions, but they are not following. Well, only one page I will show from the record.
No, but then he doesn't have a copy at all.
My lord, it may fix tomorrow, my lord. I will
If he can give me a copy right now, my lord, it will be.
I don't have right now. I will, in course of today, I will give,
Very well.
let it be fixed. tomorrow.
Yes, my lord, no difficulty.
Affidavit of service is not ready. Let a copy of the writ petition be served upon Mr. Shatadru Chakraborty, learned advocate, who usually represents the department before this court. Stop. List the matter day after tomorrow.
The day after tomorrow is the last date, my lord.
Oh, what can be done?
Tomorrow, my lord, I will hand over today itself. They will try, my lord. If it is possible tomorrow, it can be taken. Kindly, my lord.
Private respondent is also there.
My relief is mainly against the official respondents. They are ineligible. The department made them eligible. I can show from the record. No right was accrued to them.
Very well, my lord says tomorrow.
My lord, I am deprivileged.
It will be difficult.
Item number 9. Definitive 3 of 2018 with 10 on of 23.
I pay for the petition, my lord. We have. We have sent the notice through registered post.
Yes,
We have not yet received the track report. And
then next circuit.
you know, sir, in this case, the respondent all along in the execution petition, even on 21st, they have filed an application on 10th August. They are represented by an advocate. The same.
Why don't you, sir? The advocate is not receiving notice, you said.
Yes,
Then what can be done? Till the service is over, we cannot take.
this is the application just filed in the.
Service is not complete. List in, service is not complete. List in the next circuit. Service in the meantime.
Obliged, your lordship.
Item number 10. SAT on of 2023 with 10 on and can 2.
This is the second appeal. My lord. Here, my lord, leave to appeal. I have filed an application for leave to appeal, and since leave to appeal was filed, therefore I have to serve to the other side.
My lord, I am for the other side.
My lord. We are the legal heirs of the defendant who died during the pendency of the appeal. So
The appeal was contested, my lord. Even the advocate for the appellant was present at the time of hearing. He did not disclose before the honorable court that the appellant died during the hearing. Even my client died during the hearing. I praised before the honorable court and I substituted my legal heirs. It was not put in my knowledge. Even the counsel who was engaged by the then appellant, legal heirs, father of the appellant, was not informed the court.
So, my lord, a decree was passed against a dead man, which is not permissible under the law. Because
But-
suit appeal
How
was.
will the court get to know that the person is dead? Till
Yes,
is
it
brought to
was
the
a
notice
contested
of
appeal.
the court?
My lord, may
That they
kindly
have
see the
done.
judgment.
But the law is that, my lord, once a person died and within the time frame it is not substituted, suit is abated, and any order passed in an abated suit is a nullity, my lord. And there is judgment of our own high court on this score, my lord. So,
But on the other
now
side, my
today-
lord has to kindly appreciate
today
the
we are
fact
on,
that
my
the
lord.
counsel was on record. He argued the
Second
matter.
stage.
No, today we are on with regard to leave to appeal. The legal heirs will be allowed to challenge the same.
For that, I am not standing in the way, my lord. It's their statutory right. I cannot stand in the way.
In item number 11, my lord, in 10, it is within the time and the defendants, respondents have challenged it. In 11, there is an application for leave to appeal. Essay 2, my lord.
Essay 2. Let me see. File of item number 11.
मेरे को ऐसे बन गया है। मेरे को फंसा दिया। इसमें मेरे को लीव का है। गलती से मन लिखा।
Can one and
पहले लीव होगा ना वही है।
जिसमें लीव की जरूरत नहीं है, वो 10 नंबर लगता है, जिसमें लीव there is an application for leave to appeal.
this is application for leave to appeal is can 1
Can,
in SAT 2.
my lord, my lord.
Can one is application for stay.
Then can two maybe, my lord.
Can two must be in SAT one. Department.
Sat 1 year.
Where is can
No, my
two?
lord, otherwise it would be in item number 10.
Yes, item number 10.
Vinod Chandra Das, my lord, the appeal which was filed by.
Vinod Chandra Das.
My lord.
Can one? Can one
I'm sorry. ma'am.
need to challenge the judgment and appeal?
You can
And
check.
the applicants are,
The son and daughter of Viju Bala Das, who was originally defendant number 4 before the trial court. But subsequently in the trial court, she became defendant number 4 because one name was omitted, and in appeal, respondent number 4 before the appellate court.
मेरा फ्रेंड का डेफिनेटली become 50 rules clear. नहीं ना, हम बाबा
please come. An application seeking leave to challenge the judgment and decree passed by the additional district judge has been filed at the instance of the heirs of the deceased respondent number 4
My lord,
in the
appeal.
appeal.
Yes.
Stuff next. It has been submitted by the learned advocate representing the applicants that a decree has been passed against a dead person, and accordingly the present application has been filed seeking leave to challenge the judgment and decree. Stuff next. We have heard the learned advocate representing the applicants and the learned advocate representing the respondents, all the respondents. Stuff next. The as the rights of the applicants may be infringed for not affording an opportunity of hearing to them in the appeal. Accordingly, the application seeking leave to challenge the judgment and decree is allowed. Can application stand disposed of? This is item number 10. Can one? Now stay, you will contest.
So that they will contest, but second appeal, substantive question of law is to be framed.
Is to be framed.
For that, they don't have the right of audience.
Yes.
First point is, my lord, no decree can be passed against a dead person.
No, in that case, what is going to happen to can two stay?
Stay, my lord, that has to be taken before the.
Single bench. Single bench. Now. This is SAT 1. But why 2 SAT has been filed? I cannot follow.
Well, this was filed by the deceased, the children of the deceased. And other was filed by the other respondent before the.
Okay. So different parties. So
The respondents, number 1 to 3 has filed it.
so SAT 1, no further order can be passed now.
No.
And the
The substantive question of law is to be framed in both the matters.
in the
Both the matters. Now leave has been granted. Now they have to justify what will be the substantive question of law to be framed by it. My lord, it's a judgment of reversal, my lord. Trial court allowed the case in favor of the respondent. Appellate hearing, and the appellate court reversed the judgment. The case was for partition, my lord.
I get it, but then for framing points of law, we require to hear you. Before the next circuit in that case. Let the matter be placed before the next circuit. For framing the questions of law on which the appeal may be admitted. Can 1 in SAT 1 is disposed. Can 1 in SAT 1 is disposed. And the other portion will go in both the 10 and 11. Next circuit for framing the questions of law.
And for the respondent number 1 to 6.
Service was complete. Against the private respondent, your service is not. So I'm praying, my lord, this will be
Next circuit.
My lord, I'm appealing for the private respondent.
You are there?
Number 7.
No.
Are there any other respondent?
No,
No,
we
Then-
are appearing well and good.
so you have
Let
received
us
a
see.
copy. MS. Yeah, really, I don't know.
There are 3 can applications, my lord. One is for condonation of delay. Another one is for leave to file the appeal. Third one is stay of the impugnment.
Why leave? You were not
a
party?
to the proceedings. Before the honorable single bench.
No, no.
Your
the
lordship,
private-
I raised the point of maintainability. The direction has already been complied with.
Maybe.
Order has been
Already
complied.
been complied.
And is the appellant over here prejudiced by the order that has been passed?
There are several, no, it is the
Let us see the
fixing senior.
impugned order. Let us see the impugned order.
Impugned order.
December 16, 2022.
My lord, page number 12. They have to approach the tribunal, my lord, it's a service matter.
Service regarding what?
He's working in the MES department.
Yes,
Military
regarding,
Engineering Service.
regarding fixing seniority list.
Yes, he has to approach the tribunal.
If
There
the High Court did not have the jurisdiction to entertain the issue, then what happens?
No, the direction was simply to consider the
How
representation.
could the direction be passed?
Only representation was considered. Only
Any order
representation
that
was
is
considered.
passed without jurisdiction, even if
Yes, Namitu.
it is a mere representation to be considered, it
Even-
will be a nullity.
Even thereafter, the private respondent also submitted the representation and his representation was also replied.
We can take that you have considered the representation ignoring the court's order. That is one
Yes.
thing. But then the order passed by the court without jurisdiction is an
The
absolute nullity.
Representation was considered and on.
Do you admit the service is of the department and it has to go before the tribunal? The issue.
Now the earlier the
Tell-
seniority list.
Earlier, later is different. Tell me whether the issue is triable by the tribunal or not.
Lordship, seniority has been now rightly
So
fixed.
I do not want to go into the merits. You tell me whether the issue could at all have been decided or considered by the High Court at the first instance. Appellate stage, it is all right. Show me that the cause of action arises from the service matter of what you said,
Page 12, my lord.
page 12. Yes, that is the order.
Well, that is the order.
Yes, the pray for the director upon this have to dispose of the representation. To grant seniority on the basis of the mazdoor.
He may be seen seniority.
Yes,
If it is a service matter, any representation also not entailable before the honorable single bench.
and this service matter is to be dealt with by the tribunal, that this is for sure.
Yes, my lord. Section 14.
Kindly see, my lord, the page number 80,
What?
the order of the department.
That is secondary.
On the basis of the ministry's notification, this order has been passed.
Page number 18
80
of can 1?
can
No, can 1 has only 14 pages.
Matt.
Maybe can 3. The which page are you referring to?
Stay application, my lord, page
Stay application. Page 18 is the affidavit.
80 of the stay application.
80.
80.
All right.
Lecture P10. Only after the order passed by the honorable single bench, this order was passed, page 80.
Yes,
No, but then we will not go into this.
Yeah.
Yes.
Page 80, we will not go into.
yes, he has challenged it.
Subject matter of the tribunal.
This is subject matter of the tribunal. We will give you leave to approach the tribunal for necessary relief. This is.
Yes.
This order is required to be set aside, my lord.
No, how can this
No,
order?
no, this will not be set aside.
Single bench order, my lord.
I understand. Single bench order will be set
My
aside.
lord, yes, yes.
But page 80, you have
Page 80
to.
is not saying anything.
No, his prior is there.
Maybe the prayer is there,
He has challenged
but
that.
then that is, he is not pressing that. We'll give leave
My
to,
lord, yes, yes.
please come. The order dated 16th December 2022. Passed by the learned single judge of this court in WPA 317 of 2021 is under challenge at the instance of parties who were not included as parties in the writ petition. Stop. Next. A leave to appeal has been preferred on the principal ground that the writ court did not have the jurisdiction to entertain the dispute. To entertain the writ petition and adjudicate the dispute. Stop. Paragraph. It has been submitted that the matter relates to service in the
Military engineering service.
military engineering services. Stop. The tribunal is the appropriate authority to adjudicate issues relating to service matters of the military engineer services. Stop. Next paragraph. Learned advocate representing the department submits upon instruction that the order passed by the court has been acted upon. Stop. Next paragraph. Any order passed by any forum which does not have the jurisdiction is a nullity. Stop. The learned trial judge erroneously entertained the writ petition and passed necessary orders. Necessary order. Stop. It appears that this said order has been duly complied with. Stop. Next. As the order itself is a nullity in the eye of law, accordingly, the same is liable to be set aside and is accordingly set aside. Stop. Next. The appellants herein will be at leave to challenge any subsequent order passed by the department.
The order date may be 9th March 2023. Page 80.
Including the order dated 9th March 2023. Before the appropriate forum in accordance with law, if so advised. Stop. The appeal stands, the appeal and all the connected applications stands disposed of. The private respondent is represented. You record his appearance.
Item number 13, MA 3 of 23.
And for the respondent. the petition.
Because the matter is fixed for orders only.
This is regarding the,
Systems operator.
yes, the payment that is to be made in the interregnum
Yes, yes. Ma'am.
of the publication of the notification 14 July 2023, and what was the last date?
And was that Justice
Mantha's order,
Saraf initially passed the order.
Yes.
There were two directions.
right? No,
One
but then
direction.
we will crystallize it from Justice Mantha's order.
That is the order in appeal.
Under
ma'am.
challenge.
Under challenge. And the division bench had stayed Honorable Justice Mantha's order and it passed a
Stayed.
subsequent order.
Stayed till the next date.
Yes, and a subsequent order was passed whereby, my lords, the scope was somewhat enlarged because the predecessor division bench presided by Justice Dash directed the registry to expedite the process of.
That has been done. So that part has been taken
Yes,
care of.
They are not, they are pressing. the
Now,
other-
yes, now it is only the arrears of the enhanced amount from 1st of October 2018.
And the order passed by the Lieutenant Governor rejecting that
Not
request.
Lieutenant Governor.
No, it is passed by the competent authority, communicated by the secretary, or let me say, order passed by the administration, rejecting that.
See, part has been complied with by publication of this Gazette notification.
Yes,
Now, this is the balance portion. It's from 1st of October 2018. The principal bench employees are getting it. There is no
Right.
reason why they will not be given.
so
So,
may pass order.
yes, yes, please come.
No, of course, there is a difference, but my lords, eventually your lordship
Yes.
will have to.
It has been brought to the notice of this court that a gazette has been published. No, that a notification has been published in the Gazette dated 14th July 2023, publishing the rules called the Calcutta High Court (bracket open) computer technical manpower for Calcutta High Court, comma, circuit bench at Port Blair and district and sessions court, comma, ANN Islands Recruitment (bracket close) rules 2023. Stop. It appears from the said notification that there is a provision for absorption of the officers presently engaged. Stuff. With the publication of the aforesaid notification, the direction of the order passed by the court has been complied with to a considerable extent. Stop. Paragraph. Right now, what is impugned herein is the decision of the learned single judge, whereby direction was passed for payment of arrears of the enhanced amount from 1st October 2018 without interest within a stipulated time frame. Stop. Next. Paragraph. Admittedly, it appears that the employees of the principal bench are getting remuneration at an enhanced amount from 1st October 2018. Stop. There is no reason as to why the same principle will not be adopted in case of the employees at the circuit bench of Port Blair. Stop. Next. The apprehension of the administration that persons in similar posts in other offices could raise similar claims and parity was duly considered by the single judge, and it has been categorically mentioned that the order passed will not create any precedent for any other similar employees claiming in the Andaman and Nicobar administration, and shall be treated as a direction meant for the benefit of the writ petitioners only. Stop. Next. With the aforesaid direction of the learned single judge, the apprehension of the administration appears to have been duly taken care of. Stop. Next paragraph. Accordingly, the administration is directed to comply with the direction passed by the Honorable Single Judge on 15th December 2022 and to pay the arrears of the enhanced amount from 1st October 2018 without any interest within a period of 3 months from date. The appeal stands disposed of.
Item number 40. Here DB on of 2022.
I propose the state, my lord.
This is the matter where before entering into the minutes, I have made submission with regard to the CD.
Can we finish it within this
I
circuit?
do not think it possible.
Especially we are at the end of the circuit.
Because this appeal, I think, was very
It will take
honestly,
time.
on first blush, total murder, this, that is all fine. But when one goes into the circumstances, because it's a beautiful case demonstrating that chain of circumstances, how if the links fail, the chain fails. But for that, I have to take it also through detailed thing in the evidence. The only thing is in the interim, my lord would kindly deal with that issue because
Which issue?
the CD that was exhibited, exhibit 16, permitting me to inspect it.
Okay.
My respectful submissions, my lord, that let the matter be heard on merits already, on the basis of the materials already on record.
On record, we are not entering, so the court will not enter into the CD, whatever is there.
Let that be done and let us move to hearing over the matter.
So let it be before the next circuit, nothing, no.
Let that be recorded.
What is the requirement?
Because if.
Because this is his stand and he is possibly not going to change his. There is no requirement of.
No question of recording.
Do
My only submission is that it may be decided on the basis of the materials on record.
The parties agree that the appeal will be decided on the basis of the materials already available on record.
On record.
Stop. The CD, the contents of the CD was not within bracket exhibit 16. Exhibit 16 collectively.
Yes, technically it would be correct.
It would be collectively, yes. Collectively.
No, the
was-
court has not marked it correctly.
I have seen it.
I'll just check.
Yes, collectively was not
Yes,
opened.
I'm sorry, I stand.
was not opened or
Going by the index.
viewed by either of the parties. Stop.
My lord, the certificate and the CD have been marked collectively. Exhibit
Yes.
16.
Certificate is there,
And the envelope in which the CD is.
not the CD, we have mentioned the certificate, Now, please read out what is there. Yes, Yes, the contents of the CD was not opened. Very well, very well. Let the matter be posted in the next available circuit.
Grateful, madam.
Item number 15, CRA DV 4 of 2022, which grant 2 of 2022.
Marriage certificate, where is it? Yes. And appears on behalf of the respondent. So, let the matter be placed in the next available circuit. Stop. Let a notice be served upon the respondent. Very well. Next circuit in that case.
Item number 16, CRA DB 5 of 2022, which grant 2 of 2022.
It's appeal, the criminal appeal.
Yes. Where is the respondent? Nobody is appearing. In same order, next circuit.
Item number 17, WPCP 7 of 2022, which can on of 2023.
My lord, I am appearing for the petition.
Yes.
My lord, with my CAN application, I have enclosed the documents to show the subsequent development in the matter. Here the background of the matter is that the petitioner along with some other person separate original application has been filed before the Honorable Central Tribunal challenging the recruitment process of the post of primary school teacher. My writ petition before the landed tribunal was dismissed not on merit, but on the ground that during pendency of the original application, the department straightway cancelled the entire selection process. On that score, my original application has been dismissed as infractuous on the ground that the selection process was not more there. Another writ petition, original application was pending at that point of time. In that writ petition filed by Litton Baroi and others, that certain direction has been given. I have challenged the order before this division bench of this honorable court, and they have also challenged. In that writ petition filed by Litton Baroi and others, this honorable court directed the respondent authorities to issue this appointment letter. And the administration, the respondent authority challenged that order passed by the division bench of this honorable before the honorable apex court. And matter is pending there. I think that there is a stay order also. Now, what happened during pendency of this matter and those matters before the Honorable Apex Court? The departments have re-advertised the post. And in the re-advertisement, there are 177 posts and 198 posts which was involved in the SLP pending before the Honorable, that has been reserved.
What
On
does
the
this reserved mean?
My lord, kindly come to the
Post.
Yes, it has been stated that the above number of vacancy is in addition to the 198 number of
Is
posts.
in addition.
In addition.
So 198 is separate.
Separate. I am not included that 198.
Yes.
So my here in this writ petition there are 4 posts. 4 posts. So if my posts are included in the present vacancy, which is 177 posts, if the department is allowed to fill up entire 177 posts.
No, but then your post is there in 198.
No.
Yes, that is exactly.
Not there. Not there. Because that is the list prepared by the department for the selected candidate.
You are not there.
I am not there. My name is not there in the list.
May I
I'm not there.
after my learned senior?
Yes, we will hear you.
Yes.
I am not there. My name is not appearing in that list. So my
And the next list for 177 candidates.
Yes,
you have been there. Your
no,
name
this is the
not
fresh vacancy.
fresh vacancy. Why don't you contest?
Fresh vacancy. If
Why
I
don't you
contest, in the fresh vacancy,
Yes,
in that case, the writ petition filed before the shop will have become infractuous.
You
Because I
want
have-
to keep your leg in both the boat.
No, thing is that,
Before
I-
198, you want a claim over there? And
no,
where
I am not
177?
claiming that 198. Because there are posts of 224 posts. And only 198 posts are involved in the SLP before the Honorable Supreme Court. But there are some other posts also vacant. I am claiming in that.
Take a stake with the 198 posts which are pending before the Supreme Court or not?
No, my name is not appearing in that list.
And the 224 posts you say is there.
220 out of 224 posts, 198 post has been reserved.
Yes.
And now there is some new vacancy. The remaining post and the new vacancy counted 177 posts. And in this 77 posts, I am included in that post.
You are included.
Included in 177 because of the reason they after 198 there are posts of 26 posts. That 26 posts has been included in the present vacancy.
Where is the harm? Where is the harm?
If this 177 post has been filled up by the department, there will be no post.
No, but then why don't you contest? It's a fresh recruitment process. You can always contest.
No, thing is that I have challenged the 2018 recruitment.
That has been set at naught.
That has
been cancelled.
No, not cancelled. Not cancelled. Cancelled by the not cancelled by the department. And because of that reason, my original application has become dismissed as infectious. And when the division bench of this Honorable Court in the case of Littenberg in the same recruitment, the specific order has been passed to give the issue the appointment letter. In that means the recruitment process has been revived. That cancellation order by the department has been set aside by this Honorable Court.
And that is under challenge.
That is
before
under
the
challenge,
Supreme
which
Court.
is pending.
Before the Supreme Court.
Yes. So cancellation order is no way. Cancellation order has been set aside by this Honorable Court. Because in that recruitment rule, this Honorable Court directed the authorities to issue the appointment letter.
I am still yet to follow as to why you are prejudiced.
Make an effort to, my lords.
Yes.
If you permit me.
Yes.
My lords, what has happened here is it's a bit complicated, my lords. Initially, the recruitment process was carried out.
Yes.
In that recruitment process, there's a list of eligible candidates which was drawn out, that 198 which he's talking about. My learned seniors clients participated in the recruitment process but were found ineligible. So they were there, they were laying claim to those 198, but they did not make it to the list. So their names are not there in the list. Now what happens after this, the administration says there is a lieutenant governor takes a decision that this process of recruitment is not correct. So what they do is the administration scraps this list. So he has already filed a writ, he has already filed an original application before CAT saying that no, this one, I should have been there in that 198, not the people who are included in the list. But then suddenly what happens, the administration scraps the list altogether. That decision of scrapping the list is challenged in the matter of Littenberg. There eventually the division bench says that I'll give the decision also, but once let me just.
I have enclosed the decision.
It's enclosed also. So the division bench says this act on the part of the administration of scrapping the list is bad. So what is the consequence of that? The consequence of that is that that list of 198 persons gets revived. Once that happens, his cause of action also revives, because if the list itself is scrapped, then there is no, then his cause of action comes to an end, because his cause of action survives only if the list is there, but his name is not there in the list. So now after the division bench's order, that decision to scrap is set aside so that 198 revives. When that 198 revives, the persons, private individuals who actually subsequently participated, or rather who are interested in the scrapping of that list, they file a challenge against that order before the Supreme Court. They say that no, the decision of the Lieutenant Governor to scrap was correct. In that SLP, an order is passed that in the meanwhile, we direct that hereafter appointment letters in terms of direction of impugned judgment shall not be issued. So these people, the Supreme Court says that
in terms of the division bench's order, once the list is scrapped, appointment letters were to be issued by the people with whom he is competing. So appointment letters will not be issued. So the effect of this is what my learned senior submitted, that those 198 posts, appointment letter is not issued. So therefore, now in my humble submission, his grievance is protected by the Supreme Court's order, because unless and until appointment letters are issued to those 198 people, he's still in the contest. It is only when those people are given appointment letters, or rather that process is taken further, that his cause of action arises to say that it shouldn't be them, but it should be me. But he is in contest for those 198 posts only. How can he separately say that if there are 77 other empty posts, I should be reserved in that? He's not a contestant at all for the remaining 77. That is a fresh recruitment process. It is not, if he succeeds, he will be included in the 198. He won't be included in 198 plus 4.
Can he not participate in this?
Of course he can participate.
He can.
So, or if he wants some direction, he should go to the Supreme Court, because that matter is pending in the Supreme Court. If he wants that some kind of protection, he may very well go to the Supreme Court and say that when this, before finally concluding this proceeding, kindly hear me also, or he may seek a transfer of this writ petition to the Supreme Court, that because see, if eventually in the Supreme Court proceedings, if the SLP is dismissed, for example, then what happens? Then again those appointment letters will have to be issued. If the SLP is dismissed, those 198 also goes, he also goes. So, but if before that, since he has filed a writ, he wants to be heard, his remedy is to go to the Supreme Court, or else he has to wait for the conclusion of the Supreme Court proceedings, and then he has to immediately
Where
seek a
is the
stay.
notice of fresh recruitment?
My lord, page number 46
40?
of my CAN application.
Yes, 11 July 2023.
Yes.
Are you eligible to participate?
Some of them are
Overaged.
overaged.
But even otherwise, they are ineligible candidates. How can?
My lord, can you see
Why
that?
ineligible?
No, they were
Guys,
they were ineligible
the
initially
earlier-
also. They are
in the earlier
in the
round.
earlier round also.
what is the ground of ineligibility?
No, they didn't make it to the list, my lords. They are
That is on merit.
merit is the list.
That is on merits.
Yes.
That is separate.
Yes.
198, we are not touching. 177, the fresh one. The persons who are eligible, they can always
Yes, of course they
participate.
can participate. Yes, of
My lord,
course.
can you see the note portion? The above number of vacancy is in addition to 198 number of posts, which is under sub judice in apex court.
Yes. so
Sub
that
judice
is
vacancy
separate.
has not been included in the present vacancy. That means the vacancy is 198 plus 177.
Yes, so
Total
the
vacancy.
is more.
Total vacancy is more. 198 has not been included in the present vacancy, and in the list of 198 candidate, my name is not appearing there.
No, but
I have
198 has been revived.
No.
Revived but pending with the
Revived pending in Supreme Court.
Yes.
So
Yes.
Now thing is that at that point of there were not only 198 posts, there were 224 posts. So I am claiming that
So whatever your claim, you go before the Supreme Court and you lay your claim
thing-
there.
my lord, thing is that my original application has not been dismissed on merit. No hearing was conducted as because the selection process has been scrapped out. My original application was dismissed as infractuous. And at that point of time, there are some other applications challenging the same recruitment
I
process were
understand
pending.
it, but then you
Yes.
can always come up with a leave to appeal and go over there.
Yes, the
Why
thing is that once the
will 177
My lord-
be touched?
my lord, here only it is stated that as because the 198 post in the case of Litton Borough is pending before the Honorable Supreme Court, matter is sub judice, so that post has been included from the present vacancy.
Excluded.
Excluded from the
From the
present vacancy. It's from the present vacancy. My submission is that there are 5 posts in this writ petition, 4 posts, and another writ petition, 1 post. That is also sub judice before this Honorable Court. So why
No,
they are
no,
not
that is-
reserving
How is it sub judice?
sub judice? Because I have challenged the selection process. Matter is sub judice.
No, his 5 posts are within that 198 post. If he succeeds, he will be included in the 198 and 5 people will get out of the list. He doesn't have independently plus 5. His right is he's protected under this, in fact.
If the SLP filed by the administration,
Not
before the Honorable
administration has not filed, private party has filed.
Supreme Court, in which the stay order has been passed by the Honorable Supreme Court, that SLP is dismissed. They are to comply the order passed by the division bench of this Honorable Court. they will straightway give appointment letter to that candidates included in the 198 list of 198. My name is not appearing there.
So you
They-
challenge it before the Supreme Court.
My,
How can the-
let me complete my submission, my lord. My name is not included. I will be not given the appointment letter. Now, they are going to, the remaining post is now, the present vacancy is 177 posts. If they are allowed to fill up this 177 post will be, where I will go? I will go. There will be no post.
My
There will be
lawyer
no
has to intervene in the Supreme Court, my lords. I don't have to advise, but he have to intervene in the Supreme Court proceedings.
When the matter is pending before this honorable court and posts are sub judice,
He has
posts are sub judice before this honorable court. My submission is that.
177, there is no order staying, interfering anything of the sort.
Yeah.
Your claim is with 198. 198 is sub judice before the Supreme Court. You take steps.
Let that be clarified.
Who will
Let there
clarify
be
it?
that-
Why will we clarify it in this 177 posts matter?
Whatever the
The
submission
court is
made
not
by.
here to give you advice.
My lord, what happened? Mr. Chakraborty submitted before this, I am included in that 198.
No, not included. You are contesting.
He is contesting.
Not included.
He is candidate, not selected candidate.
And the submission also made by Mr. Chakraborty that if I succeed in this writ petition, then I will be included.
Not in this writ petition. In 198 petition.
Yes.
Yes, that.
No, in there, in
This is
this
only
writ
198.
petition
Same
also,
writ petition.
my case before the honorable tribunal as well as before this honorable court is that I should be included in that 198 post. Because I am securing more marks
That
than
is
the
why
candidate whose names are.
To approach the honorable
Court.
Supreme Court where the matter is pending and get things sorted out.
Yeah.
Otherwise, I do not think we can grant you any relief in this petition. But then you are the better person to advise. We are not here in the advisory capacity. But here I do not think we can give you any relief. Please come. Which is the order impugned
That is in the writ petition.
in the writ petition? Liton Baroi?
No, no, no,
No, no.
no, no.
Then? WPCT?
I'm coming to you.
Huh? Mhm. Give me the page number in the OA, in the WPCT.
Impugned order is 26 November 2021.
Yes.
That is my lord, the last annexure.
In the matter of Liton Baroi or what?
No,
In
no, senior.
2611.
Yes.
Sumanto Das.
Sumanta.
In fact, the same party has gone to the Supreme Court. So similarly placed person has gone.
Same party means?
The Sumanto Das is the petitioner. I just give the order. This is the order of the petition. It is not. This Sumanto Das.
Here it is Amar Mujumdar and others.
Now this Sumanto Das has only gone to the Supreme Court.
Rakhan.
Similarly placed party who was their compatriot before the CAT has approached the Supreme Court because the event could be similar.
Was Amar Mujumdar and others a party in this order dated 26th of November?
Yes, yes.
Yes.
They are the co-applicant.
Co-applicants. So your co-applicants have gone there.
Yes.
You also go there.
He has not challenged the order before this honorable court. He straightaway.
Or whatever.
That is the.
Now, if it is, the issue is pending before the Honorable Supreme Court. The matter relates to a recruitment process initiated by the Andaman and Nicobar administration For appointment of primary school teachers. So the petitioners contested the recruitment process, not contested, but participated in the recruitment process and were unsuccessful. Stop. It appears from the submissions made on behalf of all the parties that the said issue is presently pending consideration before the Honorable Supreme Court in special leave petition within bracket civil bracket close diary number 11083/2023. The aforesaid special leave petition has been filed at the instance of the co-applicants who were there along with the present writ petitioners before the learned tribunal in the original application. Stop. Next.
Number 217 of 2019.
Which number?
Original application.
Original application being OA 351/00217/2019. Paragraph. The petitioners have filed a connected application wherein they have challenged the act of the administration in publication of a vacancy notice dated 11th July 2023 for filling up the vacant posts of primary school teachers. Stop. Paragraph. Submission of the petitioners is that if the subsequent recruitment process is permitted to be conducted and concluded, then the chance of the petitioners being appointed pursuant to the earlier selection process will be jeopardized. Stop. Next. We have perused the vacancy notice dated 11th July 2023. Stop. It specifically mentions that the vacancy which is sought to be filled up is in addition to the vacancies which are sub judice before the Honorable Supreme Court, and the sub judice vacancies are not included in the present vacancy notice. Paragraph. It appears that the apprehension of the petitioners are misplaced. Stop. The petitioners are laying claim to the recruitment in the 198 vacancies, which is a subject matter of challenge before the Honorable Supreme Court. Stop. The petitioners are yet to participate in respect of the subsequent vacancy notice dated 11th July 2023. Stop. The prayer made on behalf of the petitioners to interfere with the subsequent vacancy notice dated 11th July 2023 cannot be accepted by the court. Stop. No relief can be granted to the petitioner in the instant case. The writ petition stands dismissed. Writ petition and the connected application stands dismissed. Add one more line. Add one more line. It will be open for the petitioners to take necessary steps before the appropriate forum for redressal of their grievances, if so advised.
My lord,
Where we have mentioned the 2023 vacancy notice, the last portion, for filling up 177 posts. For filling up, yes, the last one, 11 July, yes, right, in respect of 177 posts.
My lord, my specific request to exclude the post involved in this petition from the present vacancy. This is my only prayer.
Your prayer appears to be misconceived.
Argue the matter on me.
You cannot keep.
I
your
argue the
fingers-
writ petition on merit.
Yes. Which writ petition? We have disposed of everything. The CT and the CAN. You go before the Supreme Court.
Item number 18.
Lordship, in this matter, I am for the petitioner. I am for the petitioner, Your Lordship. The appeal was filed, Your Lordship, against the judgment or order passed by the writ court, Your Lordship. Now, Your Lordship, kindly appreciate the. My client died, my lord, this is this. Died, it's true, Your Lordship. May I,
Substitution has to be
No,
effective.
not required, my lord. This- may I submit my case, Your Lordship?
The Senior Citizens Welfare Tribunal passed an order evicting my daughter from my suit property. He is fighting with me. I approached the tribunal. Tribunal passed the order. He challenged by filing writ application. Writ application was dismissed. After dismissal of the writ application, my client died.
So what remains?
Nothing
No,
remains.
no, Your Lordship.
Infructuous.
I kindly appreciate, Your Lordship. A certain order observation has been made by the trial court, state court, against which I have filed the appeal, Your Lordship. Now, during the pendency of the appeal, Your Lordship, the client died, Your Lordship. My learned counsel client died, Your Lordship.
That means the father of the.
Father of the petitioner died, Your Lordship. Now, Your Lordship, the contention before the learned trial court was that, Your Lordship, though it has been come to the senior tribunal, Lordship, my contention was that, Your Lordship, that Your Lordship, the suit property, the land which has been allotted, Your Lordship, it is for the benefit of the family itself, Lordship. So now the situation is that, Your Lordship, the writ court's observation remains there, Your Lordship. Though kindly appreciate, Your Lordship, though I have filed a civil suit, I have filed a civil suit claiming the partition, Your Lordship. That is pending before the civil court also, Your Lordship. In that also, I have made the learned counsel client as a party, Your Lordship. So I will be taking appropriate step for deletion of. In that, Your Lordship, the another sister also has been made as a party. But this observation with regard to the property, Your Lordship, that
Where is the observation?
Yes, Your
Please
Lordship.
show?
that is hampering me, Your
My
Lordship.
lord, that is a finding of the
Let it be.
finding fact by the honorable.
No, Your Lordship.
Let us see, let us
Yes, sir.
see.
Yes.
Page 8.
No order can be passed. It's a dead person. my lord.
No, if simply my appeal has been dismissed, Your Lordship,
Yes,
it will
after
be,
going through the entire record, the order was passed.
uh, yes, Your Lordship. Page 5, Your Lordship. My contention is that, Your Lordship. On the and page 5.
The finding was recorded based on the documents
No,
filed by
no.
Leonard friend by the.
In the
honorable
in that
single
document,
bench.
in that
Show me, show us the place.
Page
the
5, para
judgment.
7.
judgment, page 5, para 7.
Yes.
My contention is that, Your Lordship, I will come to that contention, Your Lordship. Yes, Your Lordship. May I start from the first page, Your Lordship?
Show us the portion that is offending you.
This is the portion, Your Lordship.
Page 5, para 7.
Page 5, para 7.
Para 7 and Your Lordship comes to
See, the property was in the name of the father.
Father.
The father has died. Now it will go to the children.
yes, Your Lordship. It's true,
Then
but the only contention, Your Lordship, may come.
The appeal becomes practically
No.
infructuous, my lord.
Uh,
Time died, everything is over.
Page 7 will be seen, Your Lordship. Just
yes, page 7.
7,
Show us.
page 7, para 15, Your Lordship.
Para 15, yes.
There is no doubt that the private respondent number 2 is a recorded owner of the said land and the said land wholly and exclusively belongs to him.
Right.
This court is also of the view that the provision of government order dated 17 August 1987 do not apply to the land of the private respondent. This is the offending thing, Your Lordship. My contention was that the land which has been allotted to the father is under the scheme, 378 scheme, Your Lordship.
The document also speaks to your lordship, it is allotment land. Now, as per the local land, your lordship, the allotment land is for the benefit of the family, but it is allotted only to the head of the family, your lordship. Now, I have claimed before the civil suit, your lordship, that in this contest, the land has been allotted by the government in the name of the head of the family, but it is for the benefit of all the family, your lordship. So this observation, your lordship, that no doubt it has been exclusively recorded in the name of the private respondent, no doubt. But it has come under the scheme, your lordship.
No, that was clarified in page 5, para 7 by the honorable.
So I have filed a civil suit, your lordship. This observation, lordship, can be
That was clarified.
taken care into, your lordship, in the civil suit, your lordship. If it remains, your lordship, it will
Not under the administrative order.
Yes.
According to the petitioner, the appellant here, it is in accordance with the administrative order.
Yes. But it is not in accordance with the administrative order.
Now tell me one thing,
My lord.
your client has died.
My lord.
Now what is going to happen to the land?
Another daughter is there in possession.
But he is also
He is
one of.
I have been evicted on the ground of senior citizen, your lordship. I have the
private daughter and the father, my lord.
The father, your
The
lordship.
younger daughter used to torture like anything.
No, your lordship.
Retired government servant is 79 years old.
So he had two daughters.
Two daughters.
You are representing one and the.
I am representing.
appellant is the other.
No, your lordship. My learned friend is not representing the daughters, your lordship.
I am representing daughter before we learn at court below.
Lord, court below, Lord, not before this court, your
This
lordship.
court
Is the daughter a party?
No.
Then you implead.
Yes, your lordship. Yes.
My lord,
Yes, your lordship.
no question of this is order was passed under the senior citizen welfare tribunal.
I understand, but this is one line which is, what is the stand of the administration?
My lord, they have to.
Whatever is the stand, the court is.
No, the other action whether survives is the question.
Survives, my lord.
Whether it
No,
is
but then
in
this-
personam or whether it goes with the person, that is the
Yes.
question.
Only one thing which the appellant is saying that 17th August 1987, there is a finding that this is. The land in question was not in accordance with this government order. I do not know what is
My
the,
lord, that was
If that
clarified
can,
in pa-
if
page
that
five,
can be
para seven
modified
may be
this
seen.
honorable court, by this honorable court and my civil suit is protected, your lordship, it can be,
It
because
was clarified.
else I will be.
clarified means the court has come to a specific conclusion that this is not applicable,
Yes,
right?
yes,
Now
not
he-
allotted under the scheme.
Now
It-
he
it
is
your
agreed.
lordship.
So does the cause of action go?
My lord, party is not there, respondent died.
I can impede.
Respondent has died. Now the respondent has died does not mean that he is taking away the land. What will happen to the,
Civil court will decide in its own
and
merits.
this is going to stand in the way?
Definitely, my lord, the finding of the fact by the. honorable-
Yes.
This is finding of the fact by the honorable
This
civil
is
bench.
to
my lord.
be, you have to
And if
address us on this issue.
the
17th
administration
August
can, yes, your
1987.
lordship, it is 100%.
It is not allotted under the scheme.
It is your
If
lordship.
it is allotted under
It
the
is your
scheme,
lordship.
200 square meters.
Not your lordship, it is your lordship.
Please,
The administration can
I'm
bring
not saying,
that.
I'm not
In
saying
the,
saying from the air,
in
I'm
the
saying from the
record-
record.
No, your lordship, in the record of rights, your lordship, it is clarified, it has been allotted under the scheme, your lordship. It is your lordship. The.
No, but the
administration-
point, my lords, is that the learned single judge has, after hearing the parties, arrived at a conclusion.
And the
That is
one
his
of the
challenge.
parties is aggrieved. He is very well.
Challenging, my lord.
Yes, in the meantime,
Let the
one has
administration
expired.
bring the,
So-
bring your lordship.
The appeal has to be heard,
it
then
has to be hard. And how can it be hard till the
Implementing your-
substitution
they will
takes
have to be
place?
brought on
Yes,
record.
your lordship.
Or that question can either be decided first or it can also be decided at time of final argument, both points. Otherwise, it's a preliminary issue, my lords, that whether the cause of action survives, that is also has to be addressed.
Because it is only this line, this recording of fact, which is standing in the way of the appellant before the partition suit.
This is recorded based on the affidavit filed by the.
Let the
So
admission
he's
bring.
challenging that.
It's challenging.
Had your client been alive,
Is otherwise,
then it would have been otherwise.
paper book direction will be given.
Yes. Now he has expired. Will that mean that the cause of action will go? Because he is
In my
agreed.
opinion, it goes, my lord, because It is against the individual.
What
Election order
about
was
the
passed.
recording of fact? The recording of fact.
Based on the records, my lord, recording the.
You
fact-
say it is on records and he is disputing it.
No, it's on writ petition, it is not my writ petition. Yes,
I
he has
get
only
it.
challenged.
I get it, but this is what he is disputing. If he would have admitted, then there was no occasion to file the appeal.
Yes,
And
He
after the
filed the-
death of the father, everything will certainly go.
My lord, he filed the appeal because he was evicted from the property.
Yes.
In terms of the order passed by the honorable court.
Senior citizen tribunal.
Please come.
But then all the legal heirs have to be made parties.
Only one.
Only two daughters.
Two daughters.
He's not a party.
No, I will
He is
include.
required to be brought
He
in
is
record.
required to be brought on.
That is what the
Deep
submission
dive.
is.
Yes, my lord, because.
Deep dive.
Please take down. The respondent number 2. Respondent number 2 has died,
Well, I have given death certificate, my lord, copy.
has expired
18th March 2023.
on 18th March 2023. Who is the petitioner number 2?
Son-in-law.
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 We don't have copy of the appeal also, if it can
He
please.
was not given either to me also.
Please serve.
Thank you. I have received a copy. Acha.
On 18th March 2023. The heirs of the deceased respondent. Heirs, S will be within brackets. Of the deceased respondent is required to be brought on record. Stop. Let necessary steps be taken by the appellants in accordance with law. Liberty to mention.
Respondent
Let
number two name may be deleted, my lord.
He'll be substituted. What is the use of deletion now? Let an application for substitution be filed.
Right.
And I'm sure you're going to contest that.
Definitely, ma'am.
Nice.
Item number 19, CPM 43 of 2033.
Whose order?
My lord, the order passed by Honorable Justice Subroto Talukdar and Honorable Justice Ravinder Samanta.
So we can take it up.
Yes, ma'am.
I'm appearing for the contender, let the copy may be served.
You are appearing for the contender? Who is the contender?
The bank managing
Managing
director.
Director of a bank,
Managing director of a bank.
my lord, cooperative bank.
And what was the direction?
Direction, my lord, a disciplinary proceeding was initiated against this petitioner, my lord. He was not allowed to have a defense assistant. He challenged it before the writ court. The writ court said a right of audience must be there. Therefore, the court said allow him to appoint a defense counsel, a defense assistant to defend his case. They challenged it before the division bench, my lord. And the division bench held that there is no wrong in the order passed by the writ court. You comply it and you conclude the proceeding because we are retired government servant. You conclude the proceeding within a period of 6 months. For 6 months, they done nothing, my lord. I took out a contempt application before the single bench because the order was passed by the single bench. But in single bench, they filed an affidavit. I filed the rejoinder. Ultimately, the single bench held that since the order was modified to the extent that the appellate court directed to comply the order within a period of 6 months, therefore, it will lie before the division bench. That's why I have filed this contempt application now.
We didn't get it. The last portion what you mentioned.
My lord, the court affirmed the order passed by the learned single judge.
Yes.
And thereafter, the court said to conclude the proceeding within a period of 6 months.
Right.
I filed a contempt petition before the writ court
Right.
and said that the order of the writ court was violated. They took a stand that it cannot be because there is a
Merger.
modification and all. A merger and modification.
All right.
Ultimately, my lord, they filed an opposition. Thereafter, I filed a judgment of the larger bench also,
Yes.
where this issue was decided.
What was decided?
If my lord come to the larger,
Which bench has the determination to decide it?
my lord,
If my lord come to page 133, it's a reference made
Reference made, yes.
before the three-judge bench, my lord.
Yes, yes.
So there the court has said on what circumstances the matter will appear before which court. If my lord come to the operative portion, is at page 153, my lord.
In case of affirmation of the order, something like this. So the order of the Honorable Single Judge affirmed by the Honorable Division Bench,
Yes,
with or without modification, it is not mentioned, will lie before the single bench.
my lord.
Here it is the order of the Honorable Division Bench.
Division bench,
Let us see the order.
my lord. Kindly come to the order of the division bench starts from page number 23, my lord. Relevant would be page 25. Second paragraph.
Here the order of the learned single judge has been affirmed.
My lord.
Then why will the contempt not lie before the Honorable Single
My lord,
Judge?
that single judge passed an order.
Because you have relied upon the division bench judgment, the special bench judgment.
Yes,
And it says that in case of
Correct.
affirmation of an order of the learned single bench, the contempt would lie before the single bench.
my lord.
Then how will it be maintainable over
So
here?
I filed before the single judge. Single judge said it is not maintainable before me, you go to division bench. Only because of once again, my lord, come to page 25, my lord. We are litigants, my lord, wherever the
Yes, true.
my lord, kindly come to page 25, last third paragraph, my lord.
25, third paragraph.
The appellant bank shall be free to proceed with the disciplinary proceeding and conclude the same within a period of 6 months from the date of communication of this order. The court says by this, there is a modification because affirmed, but a subsequent direction was passed.
This is what I was wondering. Why is this modification not mentioned in page 153? Order of the single bench affirmation is all right, but little bit of modification makes a lot of difference.
My lord. So
The
therefore, my
bank
lord,
shall be free to
this
proceed
was-
with the disciplinary
then I-
conclude the same. And what is the stage of the disciplinary proceeding?
they have done nothing till this order was passed in the by the learned single judge in the contempt. Till that day, that is more than 8 to 10 months. They done nothing, my lord. They sit tight over the matter despite of an order of the court to dispose of within 6 months.
Very good.
My lord, let copy may be
Please,
so that we
please
will
take
file
up.
our review.
The petitioners complaints of violation of the direction passed by the Honorable Division Bench of this court on 21st November 2022. Whereby it was recorded that the appellant bank shall be free to proceed with the disciplinary proceeding and conclude the same within a period of 6 months from the date of communication of the order. Paragraph, the order of the Honorable Division Bench was communicated to the alleged contemner by the communicating letter of the learned advocate dated 24th of November 2022. Stuff. The order is yet to be complied. Stuff. Let copy of the contempt application be served upon the learned advocate.
I have served, my lord.
In that case, record copy of the contempt application has been served upon the learned advocate representing the alleged contemner. Stop. Next. Let affidavit of compliance be filed on the adjourned date. List on 20th November 2023.
Date, my lord,
20 November.
20th November, my lord.
Affidavit of compliance they will file. You want your order to be complied.
No, my lord, they have done nothing for 6 months. The court has granted them 6-month period which expired in the month of May.
Yes.
Now, my lord, if my lord give another 6 months, then we will be
Why
difficult.
6 months? We are in the end of August.
No, my lord, let it be in the next circuit because they have done nothing, my lord. We are a retired government servant. We have held up in this island only because we are not getting our dues. And because of the pendency of the disciplinary proceeding, my lord, we are getting pension.
Do you expect that the disciplinary proceeding will be over by
My lord, at the same time,
or
my lord, what I am on, my lord, because the 6 months they have done nothing. They have violated the order of the court. Now, because they have violated the order of the court, my lord, whether a subsequent time is to be given or they may be directed to close the proceeding. Because, my lord, 6-month time was given. Not even a single inch they have proceeded despite of an order of the division bench.
that will be a different cause of action, not in contempt.
My lord, contempt, my lord, after the order of the court, they have not even issued a single letter to my client to come and join the disciplinary proceeding. After 8 months, when the single bench rejected my contempt application saying that it
I
was.
get it. I
So, my lord,
understand.
Yes.
But then
My lord, it's a contempt of the court's order.
suppose contempt of the court's order, they will be punished. What relief will you get?
My lord, I want no further proceeding can be held for,
Yes.
after the period
This
of 6 months.
will be a different cause of action. If they take steps, then that will be a different cause of action. In that case, you shorten the time.
My lord, let it be.
Friday, so that there will appear virtually to Calcutta, so this matter may be.
So what? You file
No, no,
complaints by the.
have you complied the court's direction or not?
Not, there are certain changes.
The changes we are not going to see. Well, we have followed your stance. In that case, in the next circuit.
Next circuit, let it be in the
In the
next
case,
circuit.
next 20th of September.
My lord.
20th of September. If this is your stand that you will not comply because of change of circumstances, then a different stand has to be taken.
Officer appointment, so that was went to the board of meeting.
Whatever it is, we will not hear anything now. You filed your affidavit of compliance, we will see what is to be done.
Item 20 already fixed. Item 21, SCT 5 of 2022.
Here I for the appellant, there is a delay. I file affidavit of service. It is to be heard delayed by the honorable single bench. If it is delay is condoned, then for admission before the revision bench.
It has been submitted by the learned advocate representing the appellant that an application seeking condonation of delay is pending consideration. Stop. The same is required to be heard by the learned single judge. Stop. Let the matter be placed before the learned single judge in the next circuit.
Problem.
Did you serve?
Yes, affidavit service filed.
Item number 22. MA 22.
How long it will take?
It will take some time, my lord.
Then next circuit.
Item 23.
My lord, I am appearing for the petitioner, my lord. On 21st, my lord has passed an order. Can we have a note of that order, my lord? And in compliance to that order, they have filed an affidavit. Wherefrom, if my lord reads, my lord, it will find that the post is lying vacant, no regular selection process was initiated, and they at paragraph number 4 says the department is managing the work of dental surgeon through contract doctors on NHM and dental faculty of ANIMS. This is absolutely false because my client is posted.
Where is the affidavit?
It has been filed, my lord. It will be on the
It will be with the managers if it can be called for, it will be in the, it will be with the registrar.
Let it be called for, we'll take it up tomorrow. No further division bench matters today. এটা আছে 2:30টার সময়।
Oh.
2 o'clock, very To intimate.
I have already filed the affidavit of service.
Anybody appearing? This is a new motion. Very well, I'll mark it tomorrow. Day of Friday.
Yes.
Let us see.
My lord, item number 20, my lord.
Yes,
Mr. Das is there. And in some difficulty today, just not today, my lord.
item number 20, it's a
20.
hearing matter.
It's a hearing matter. There's an allegation of illegal construction and my lord has passed an order from the municipal authorities to furnish a report. So just not today, I have.
Very well, not today.
Even 21.
It's all time. Same petitioners.
Same.
Both are tables.
Very well,
I'm on one side and the
not today.
oblige.
Item number on WPA 824 of 2023.
Your Lordship, I have called the petitioner.
Yes.
Here, Your Lordship, I have mentioned the matter because no affidavit in opposition has been filed by the authorities despite there being a direction. Time has already lapsed.
Expired.
Yes.
Where is Mr. Chakraborty or his junior? Gone for lunch?
I think so. They have not come back.
Not come back? What is to be done?
Let it be not today, Your Lordship, because in any way they will be seeking extension.
No, if extension order is passed, then
Yes.
we can move forward.
Yes, yes, Your Lordship.
Thing is this, nothing more. Item number 1. Mr. Chakraborty, your affidavit is not ready.
My lord, yeah, it has been prepared, my lord, testing for short extension.
Peremptory, Your Lordship, that is not prayer.
On the prayer of the
One,
learned
this is a
advocate.
first extension, my lord, may not make it so.
No, no, no. let
On
it be
the
peremptory.
prayer,
Lordship,
since
I
it is
suffer.
getting ready, let's hope it will be prepared. I am not mentioning peremptory, but let's take it to be peremptory. On the prayer of the learned advocate representing the respondents, time to file the affidavit in opposition is extended by 3 weeks. Reply, if any, by a week thereafter. List before the next available circuit.
Let it be 2 weeks, 1 week, Your Lordship. It will appear in the next circuit. Otherwise, 3 weeks,
Even
1 week is 4 weeks.
Yes,
That
4
will
weeks,
appear on 24th.
24th.
Yes. It
So
won't appear.
1 week, 1 week you'll get in the next circuit.
Your Lordship, again, the second week, no hearing takes place.
Well, today also, my lord, there are so many matters.
Very few matters in the second week, Your Lordship. So let it be 2 weeks.
If you
1
can
week,
do it within 2 weeks,
Already
In that
ready, he
case-
says.
in that
No, no,
case,
my lord, then fine.
2 weeks, 1 week.
Your Lordship. Oblige.
Item number 2, WPA 842 of 2023.
Same, Your Lordship.
No,
item
in
number
this,
2
my
will
lord,
be-
you has been filed, my lord.
Copy will be given?
And we'll give a copy, my lord. We'll give a copy.
You are sure it has been filed?
Yes, yes.
Very well.
Yes, sir.
Respondents have filed their affidavit in opposition. Stop. Let a copy of the same be served upon the learned advocate representing the petitioner. Stop. Reply may be filed within 2
1 week.
weeks.
1 week.
Circuit will be
Yes,
the next
It's
circuit,
2 weeks.
2 weeks. List in the next circuit.
Item number 3, WPA 844 of 2023.
It would be same.
Filed, it has also been filed. ma'am.
Same order.
Oblige.
We'll give copy tomorrow.
Okay.
Item number 4, FMT 4 of 2020.
I am therefore there.
New insurance assurance company.
I have for the insurance company. My submission along with the basis on the documents was recorded by this honorable court on last occasion. Because vehicle is not insured in respect of the deceased. He was the driver himself.
You are ready with
owner
the
and
matter, sir.
driver.
You are ready with the matter. So let me place the case.
That order was, he was directed to submit any citation on that point if it is there. Lengthy order was passed by this court.
Then I am not aware of the order. I need
Yes.
to go through it.
Yes, your lord.
Do you want any citation from him or is he supposed to give any citation that I do not know?
It is upon learned
No,
counsel.
the order dated 21st February 2023 may kindly be seen once.
Yes.
What the other side is saying is not based on this order.
not based.
Yes, ma'am.
The question that arises for consideration in this appeal is whether a person being the owner and driver of a motorcycle can be covered under a policy covering third party liability. Yes, you took a adjournment on the ground that you will find out the decided cases on the point to buttress the submission.
Nothing to
Nothing
be
to
added,
be-
nothing more to be added. So based on material, I will place, my lord. I will just go with the very policy paper which comes to my aid.
In that case, tomorrow it will be fixed, Lord. It is not intent to submit any citation.
No,
Tomorrow,
it's not possible.
Ah,
You need
then
to
it-
go to the
that's- this
circuit,
has to
but I'll
be-
record his submission in that case.
Lordship, my lord.
Please come. Learned advocate representing the appellant. Submits that he does not have anything to add over and above the documents and record. The documents already available on record and the submissions made therein. So the matter is required to be heard. Stop. List before the next available circuit.
Blind.
Item number 5, WPS 757 of 2023.
appearing for the registrar of this honorable court.
Yes.
The order, payment has been made to the rate petitioner. Order
Payment
we have
for what?
received from the pay and account, he's taking voluntary retirement. Voluntary retirement taken by him and dues was there. So order has been given and
Petitioner
pay
is
and
not
account
here?
office. Petitioner's counsel is not there. Nitish is here. Yeah.
What is to be decided in this case?
What should he, other side, the rate petitioner's counsel taken time to verify whether actually amount has been paid entirely to him or not.
You
He has
must be
to-
having some documents to show
No,
that payment.
Pay
has been
and
made.
account office already submitted. Lordship.
Is it on record?
On last day. we
Yes,
applied.
I see one pay and accounts office. Where is Mr. Binu Kumar? Direct the respondent on the street regulation monthly pension. Has the payment been made? There is a direction for presenting the bill for payment.
My lord,
Has the payment been made? Let me see.
payment
this.
is made, payment
Payment-
payment has been made. Monthly,
Monthly payment?
the registrar of the
Payment of the areas. For the period from present cash. I will, is there Mr. Minu Kumar? Did your client receive payment?
My client received payment, my lord. There are other issues, my lord. If they intend to file their affidavit, let them file, because the issue is that, my lord, my client just on instruction, I am submitting, my lord, because I don't receive any document. Now they have started paying me the pension, but at the same time, an order was passed whereby the registrar has asked to submit monthly bill for release of my monthly pension. Unheard of. Now I am not in service. What bill they will submit? So, my lord, this requires whatever they want to say, my lord, let them say in
My
affidavit
lord.
so that I can deal it, my lord.
My lord.
How they can ask for monthly bill?
For
Of it.
1 minute. The registrar has also been separately advised
So
to
they hear
presenting the bill.
So-
It is not you who will prepare the bill, it is the registrar who will prepare the bill.
A retired government servant. Now I am
Yes.
going to settle in Chennai or somewhere else.
Right,
Now, what is the process of preparing a bill of a retired government servant after his retirement?
no, but then whether bill is prepared or not is a different thing, if the money is credited.
I have to get the pension. Suppose my
If
lord.
the money is credited to your account.
But at the same time, my lord, if monthly bill is prepared, if
Let them
some
prepare
reason,
their own
some
bills.
reason if it is not, then let there be an order that my monthly pension shall be
Yes.
disbursed without any hindrance, my lord. Otherwise,
Right.
my lord, for this or that
Yes,
reason,
yes.
my lord. And my lord, interest is also to be given, my lord. I retired without any disciplinary proceeding, nothing. I get the pension only last month, my lord.
Payment of arrears 55,600 plus pension relief amounting to rupees 3,49,000 something. Sum of rupees paid,
After 6 months, the pension was released.
payable amount 349. The authority may be submitted along with the bill. It appears from the submissions made on behalf of both the parties and upon perusal of the documents from the Chief Pay and Accounts Office, Andaman and Nicobar Administration, that the arrears of monthly family pension plus relief plus the medical allowance in respect of the petitioner has been paid. Stop. Next. Learned advocate appearing for the petitioner submits that the payment was made after a delay of 6 months. Stop. Prayer has been made for payment of interest on account of the delayed payment of the terminal benefits. Stop. Next. It has further been submitted that the dues of the petitioner may be credited to his bank account on regular basis. Stop. Paragraph. It is settled law that an employee is entitled to receive his terminal benefits immediately upon his retirement. Stop. In case there is any delay in payment of the said benefits,
A
comma,
slight indulgence, my lord,
the
a slight indulgence. The petitioner opted for a pension through bank. And because of his option, the government of India, New Delhi, they said that there was a difference in payment of the Calcutta High Court person attached to the Calcutta High Court and the Central Pay Commission. So they cannot do it. Therefore, the matter was sent back. It was because of the option taken by the petitioner. There was a difference of pay, the scale of pay between the central pay and the low pay which Mr. Chelli was drawing from this court.
no, but then the pay is as long as the person was in service,
My lord.
there must have been a pay scale.
My lord, there was a difference of there is a difference in pay scale by which the central governments are governed.
Why will this difference
My lord, this is
be a reason
the,
for delay in payment of the terminal benefits?
my lord, then the file was sent back. And from this, he was asked to change the option. He changed the option. Thereafter, the payment was cleared. We will file an affidavit then, my lord. Question is, we have not committed any delay.
But delay was caused.
The delay was there, delay was
If
there.
for your,
My, the option was given.
any act on your part.
My option was given. We will file, we will file.
I will place the authorities on that so that we can get the entire interest for the said period.
My lord, my lord.
What did they say?
Option taken by the petitioner.
All right. Benefits, then the employee will be entitled to receive the interest on account of such delayed payment. Stuff, paragraph. It is the specific contention of the learned advocate representing the respondents that the delay caused was on account of the option exercised by the petitioner. Stuff. There was no intentional delay on the part of the respondents in releasing the terminal benefits of the petition.
Absolutely.
Learned advocate representing the respondents seeks time to file an affidavit on the issue of payment of interest. Stop. Let affidavit in opposite, let affidavit to the above extent be filed within a period of 3 weeks.
My lord.
Reply, if any, within a week thereafter. Stop, liberty to mention.
I am appearing for respondent number 3 only.
Only 3.
My lord.
Case record respondent number 3.
I am representing the registrar of this honorable court.
Very well.
Okay.
You do not have any stand,
No, Lord.
separate stand.
No, no, no.
Very well.
Item number 6, WPA 838 of 2023.
I pay for respondent number 1, 2, and 3, my lord.
Very
My lord, I am appearing for the petitioner. I have already served the extra copy of the writ petition to my landed brother.
extra copy.
Extra copy because he has not
Will
forwarded to the council. So as per direction by
release
this
of the
honorable-
land from acquisition.
Yes, the thing is that, my lord, without any due process of law, our land measuring an area of 2,500 square meter has been set apart, and initially it has been allotted in the name of the Andaman Nicobar.
Yes, I followed. Tell me, what is the,
The fact is that in the year 1989, they have surrendered this
Why
particular
is it
land
surrendered?
unconditionally. After it has been surrendered, server number has been changed. It has in the year 1992, it has been allotted to the police department. And thereafter, the police department now approached the estate officer, and the estate officer has issued the notice for hearing before this estate officer. Instead of appearing before the estate officer, the petitioner
when
has
is the date of hearing?
the annexure P8 is the
April 2022.
yes.
What is the fate of the hearing?
That it has to be ascertained.
That was the direction given for you to ascertain on the last occasion.
What's it?
In a similar matter, possibly there was a direction passed by a coordinate bench of this court for taking into consideration the prayer for releasing the land from acquisition.
Here it is not acquisition. Here they have surrendered unconditionally in the 1989.
There is no.
Yes, there is a document. I will file it.
I have gone through the record, it has been resumed in the 1992.
Appealing for the police. Last response.
Yes. What will be your submission?
Because I am told, I've just now received instructions that the process of returning is underway.
Yeah, then
That is the, I have no.
this is what the petitioner is
Yes.
saying.
Yes. That return instruction, I don't know.
In fact, my lords, I have, for initiating eviction process, several correspondence were made by police department.
Eviction is something else. Eviction means
This
you want to evict
state
the
appeal.
petitioner. But the petitioner wants the land back. Where is the question of eviction? Opposition,
Yes.
please come. Learned advocate representing the which respondent?
I am
will-
for 1 and 2 and 3.
Respondent numbers 1, 2, and 3. Seeks further time to take instruction in the matter. Stop. Next. Learned advocate representing the police seeks time to
up to a limitation period of 60 days. And thereafter another 60 days. Almost within a period of 1 year, they opposed. So this point of maintainability may be decided on the.
When will 25th we will decide?
Item
number 8. WA 862 of 2023.
Lordship, in this matter, I am for the petitioner, Lordship. Last occasion, your Lordship was pleased to direct the other side, the department concerned, to verify that whether any appeal before the deputy commissioner is pending or not, your Lordship.
So I seek time.
You seek time?
Yes, sir.
Why? Did not get the
Your Lordship,
information?
No, madam. There is,
in the
there is a private respondent also.
in the contempt
case.
proceeding, your Lordship.
Private respondent may be there, but then you can always take information as to whether any
Yes.
appeal is pending or not.
My contempt proceeding was dropped by your Lordship on the only ground of the submission that the private respondent filed an appeal before the DC, your Lordship, against the order of the Secretary Port Municipal Council. And with liberty, your Lordship was pleased to,
Where is the service upon the private respondent?
your Lordship, I will file the affidavit service, your Lordship.
Neither. There, please come. There is no proof of service of the writ petition upon the private respondent. Stop. Learned advocate representing the respondent number 1 seeks time to take instruction in the matter. Stop. Let affidavit of service be filed on the adjourned date. Stop. Learned advocate for the respondent number 1 shall take necessary instruction in the meantime. List in the next available circuit.
Oblige, your Lordship. Oblige, your Lordship.
I don't know if service is affected, my lord.
Item number 9. WPA 876 of 2023.
My lord, I got information that service has been affected. But in the service confirmation report in the website of Postal Department, there is no updated report. So this is the position.
If Mr. Chakraborty can accept a copy, then it is all right for the department. Is there any other private respondent or any other
Correspondents are there.
department?
That is the reason.
I'll be appearing for the private performance from 4 to 9 days.
4 to 9.
Then give a copy to Mr. Chakraborty.
Don't have copy.
No, he doesn't have a copy.
I don't have copy.
I will serve.
I just saw the list and on that.
Yes.
I will serve a copy. When the service is affected, let it be tomorrow. I will serve a copy during course of the day.
What is the issue? Can it be
Issue is
decided?
that the respondent number 1
Yes.
issued a e-tender for
Right.
construction of CC road on the land recorded in the name of my mother. My mother died, mutation has not been taken place, but e-tender has been issued for construction in the allotted recorded land and investing the government money to the private property, private land. I made a complaint that no, I made an objection. No, this is a recorded land of my mother. So it has not been resumed, neither acquired, nothing, no surrender has been made. So may not construct any CC road on the recorded land. Even thereafter also, the work order has been issued to the contractor and the contractor started working.
Who
On
are the
recorded.
private respondents?
They were my brother and sisters.
They'll be pro forma in that case. Are they standing in the way?
No, my lord. Case is not like that.
Case is not like that.
Petitioner is my elder brother, private respondent.
Yes.
Brothers and sisters. Way back in the year 2015, the petitioner's mother got expired during the month of November 2015,
Yes.
leaving behind the petitioner as well as the private respondent. But during her lifetime, my lord, what she did, she surrendered a part of her recorded land for the purpose of executing this particular tender work. And the tender work started also. Almost the work up to the extent of 80% or something like that, it has been completed also. Now, even that, if to that effect, even the order of the tehsildar is also there, that during the lifetime of the petitioner's mother has even surrendered, and to that effect, that certificate is also there.
And is the construction going on that portion of the land that has been surrendered?
Yes.
Is the land
Part which has been
partitioned?
surrendered.
Is the land partitioned?
No.
No, not to partition.
Is
Part of
the-
land which has been surrendered. Upon that, the
On
tender
that
process-
land it is going on. Very well, you file your opposition.
I am filing my.
Let copy be served upon.
I will.
Yes.
When there were direction to opposition, I will serve this.
The matter is required to be heard upon affidavits. Stop. Let affidavit in opposition be filed within a period of 3 weeks. Reply, if any, within a week thereafter. Stop. Let a copy of the writ petition be served upon Mr. Shatodru Chakraborty, learned advocate representing the official respondents. What about the Pradhan?
Pradhan.
Pradhan will also be
Official.
Will you be representing the Pradhan also?
I think because one is Panchayat.
Respondent number 4 is also the Pradhan.
He is the Pradhan.
He is the Pradhan.
I can't say so,
My younger brother.
But I
He is
can
the Pradhan.
I cannot say it of
I do not know.
in his capacity.
I don't
My
know.
lord may not record that. I will.
I am not recording. This is the reason I'm not recording. Official respondents, right? List in the next available circuit.
Item number 10, WPS 882 of 2023.
My lords, this matter, my lords, although copy has been served, my lords, I have received instructions, my lords, that although I don't have the writ right now, my lords, I've left it at home by mistake. But point is, my lords, that here the allegation, the CVC the vigilance inquiry that my learned senior sought was against the erstwhile DC for not disposing of a revenue case. Now the new DC has taken up the case and hearing is fixed on 25th August. But my learned seniors clients refused to accept notice. Effort was made to serve notice. They refused to accept the notice. The hearing is fixed on 25th. They can always participate in the hearing without, if they have any other grievance, it can always be without prejudice. If they still want to go after the former DC, that's a separate issue. The DC is transferred, it's not here.
I only want to disposal of my petition dated 28/6.
If it is fixed for hearing on the 25th of
I
August,
am not concerned for the hearing.
but hearing is only for the purpose of disposal of your
I
case.
will tear my application
Which application?
that he is going to dispose of. I am not concerned for that. I am concerned for only this.
What?
Page 12, Chief Vigilance Officer.
Page 12?
His
One
petition,
minute,
yeah,
one minute. Page 12,
page 12 P1.
P1.
This must be disposed of, only I want to this.
Yes, he will dispose this
No, no,
out.
my-
Yes.
He has made a representation saying that is to conduct vigilance inquiry against the former the erstwhile deputy
Yes.
commissioner for not disposing of an appeal. Now that gentleman has gone to the mainland. Now he's transferred. The
then
new,
if the
new
file is-
deputy commissioner is now taking it up, has issued notice for hearing, but he is saying that he wants the vigilance inquiry to be conducted against the former deputy commissioner.
You want vigilance
Yes,
inquiry?
Then I file affidavit, my lord, and such, then affidavit.
If he
I'll-
wants to affidavit that within this circuit.
No, no,
Well, yes. Already I have
1 minute.
my client is,
Please.
you don't say,
What exactly does your client want?
my client want disposal of this petition.
What is there in this petition?
Petition is there is a complaint against the deputy commissioner for not disposing my petition.
Not disposing your petition?
Yeah.
Your petition will be taken up for disposal. You do not want that?
But I don't want that. I only want this complaint petition may be disposed of. Only I want this.
You do not want the main relief.
No, I don't.
So it appears that it's a mala fide petition. You want to target that person.
You not see, my client filed petition in the year of 2018. Now I am 23. What is the condition of the administration? What is
The condition of the administration is one thing.
that's why I have come with this petition.
If you
And you not see, I want to dispose of this petition. Please order. Because the executive understand us a street dog. He has no respect for us and for the advocates and for the clients. 2018, for the last 5 years, we are.
No, my lords, I will not come because my lords, my learned seniors clients repeatedly send representations on diverse issues. Some of us are personally also
Yeah,
affected. by
let
that.
him file it.
But I don't want it is not a case. I'll file, my lords. It's not a simple thing like what it is being put forth the representation consideration.
I will
Because my
not
lords,
spare
it's a reason.
I will not
We'll
spare.
file an affidavit, my lords. If it calls for a vigilance inquiry.
please come.
You not see within this circuit. If,
No, why
if
within
they
this
want to
circuit?
file,
No,
then
no.
within this.
No, my lords. We'll
What
take-
is so special in this circuit?
Not a special, but already I have left by 5 years and now he want to go on 2 years, 3 years. That's why I claim this.
You filed the writ petition on 16th of August.
16th of August. I have my petition, my client.
The writ petition is of 16th of August.
You not see,
Then
my client filed petition 2018.
Very well. The petitioner seeks disposal of the representation dated 28th June 2019.
No, sir, not 23. It is wrong date. Seal is very clear, seal from the parties.
Seal I can see is 30th.
3rd June, yeah, your lordship, 23.
Where is 23? I cannot read.
That is
Where?
30th June 2023. This.
The representation is signed 2019, is submitted
Is
23,
signed.
and you say it's pending from. I'm going to dismiss your petition now.
It is signed, but receive of the
Then why do you say
respondent.
that it is pending from 2018?
Receive of the office. Receive date is 23.
And follow date.
Yours.
Your submission is that the petition is pending from 2018, the representation.
28/6, not principal representation. This not. This is on 30th June this year.
Yes. Where is your application dated 25th of July 2018? Where is that application?
I have not annexed that.
No, you have to show.
Your lordship.
Otherwise, the court is not convinced with your submission.
Whether that petition is needed here.
Yes, yes, very much needed. I want to see what is that.
I have only paid for this petition, not that.
No, no. You cannot file writ petitions. Your writ petition appears to be an absolute malafide one.
Your lordship, then dismiss. I pray for dismissing this appeal.
You want,
I feel that I will not get justice.
you want the matter to be decided by the
Your
circuit.
lordship, I feel that I will not get justice. So please.
You have to show the documents. Is he a practitioner of this?
Yes.
He is. He is. Oh, what did I do? Representation seeks disposal of the representation dated 30th June 2023. No, representation dated 28th of June 2019, received by the Office of the Learned Governor's Secretary on 30th June 2023. Stop. The said representation mentions about an application dated 25th of July 2018. Stop. Next. The said application dated 25th July 2018 is not annexed to the writ petition. Stop. Learned advocate for the petitioner categorically submits that he does not have a copy of the application dated 25th July 2018. Stop. Paragraph. It appears from the representation submitted before the respondent authority on 30th June 2023 that there are certain allegations against the Deputy Commissioner, South Andaman, for not taking steps for disposal of the initial application filed by the petitioner on 25th of July 2018. Stop. Next. Paragraph. Learned advocate representing the respondent authority submits that the erstwhile Deputy Commissioner has since been transferred and the present Deputy Commissioner has taken steps for disposal of the application filed by the petitioner in July 2018. Stop. It has been submitted that 25th August 2018 is the date fixed for hearing of the said application. Stop. Effort was taken to serve notice of hearing upon the petitioner, intimating the date of hearing, but the petitioner has refused to accept such notice. Stop. Next paragraph. As it appears that the respondent authority is taking active steps for consideration of the representation filed by the petitioner on 25th of July 2018, and date has already been fixed for hearing of the said application. Accordingly, the instant writ petition is disposed of by directing the Deputy Commissioner to consider the said application and dispose of the same in accordance with law, after giving reasonable opportunity of hearing to the petitioner within a period of 6 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Will you accept the notice?
Notice has no served upon me.
Will you accept or will you not accept?
I will accept.
The date of hearing is clearly mentioned in this order, and it will be open for the petitioner to participate in the hearing scheduled on 25th of August 2023. Stop. Learned advocate appearing on behalf of the petitioner submits that his client will participate in the hearing, or you will participate.
I am also.
That his client will be duly represented at the hearing to be held on 25th of August 2023. Writ petition disposed of.
Highly honored. Sorry, Lordship.
Listen, you are representing your client. Today this client is there, tomorrow he'll go, somebody else will come. If this is the way you behave with the judge or the court, then what will happen? It is you who will be at fault.
Sorry, Lordship.
So don't get angry.
Sorry.
The court does not have any personal grievance against either you or your client,
Your Lordship.
right? You are doing your work, the court is doing its
Your
work.
Lordship.
Call the next matter.
WPA 885 of 2023.
My lord, in this matter, my lord, there was a direction upon the respondents to file an affidavit to show that all the notices regarding cancellation of the lease and then subsequently steps before the estate officer was served. My lord, we have filed the affidavit or served it upon the.
I'll take an exception to this. I'll be filing a reply.
Very
This
well.
is served only this morning.
Very well.
But my lord's my lord's interim order, my lords had said that it will abide by the outcome of this writ petition.
What
The
will abide?
is pending because of
What
that.
will abide?
Proceeding before the, my lords see the last order, there is some interim protection given to them.
Any steps taken during the pendency will abide by the result. It's all right.
Very well.
It's already there. Affidavit filed on behalf of the respondent numbers 1 to 6 is taken on record. Stop. Learned advocate representing the petitioner seeks time to file reply to the same. Stop. Let reply be filed within a fortnight from date.
My lords,
List the matter in the next available circuit.
would my lords clarify that proceedings are, it is clear, according to me, it is clear. my lord.
Absolutely clear.
That's-
Item number 12. WPA 888 of 2023.
I'm appearing for the Commissioner of Employees. Under the Compensation
Commissioner of
Employees.
Employees.
This is under the Compensation Act 1923. Because
All
it's a
right. All right.
Commissioner who has passed an order
Yes.
whereby the V. Narayanamma, being the respondent number 1, has been granted certain compensation amount. In terms of the act, my lord, if the appeal lies before the High Court,
Hmm.
but before appeal, they have to deposit the amount before the commissioner and get a certificate. Under the act, if my lord will see 30 is the appeal,
Who is for the petitioner?
My lords, we have filed, this is a writ petition, my lords. It's not an appeal.
Where is he?
It can come in the next circuit, ma'am.
Lord, we say because it is a beneficial legislation.
Yes,
The act says that if they want to prefer an appeal,
you
for
are,
the High Court,
you are for
for
the,
the commissioner.
yes, where is the commissioner respondent number 2? So you say that
It
the,
is not maintainable, my lord, until they file, deposit the amount before the commissioner, get a certificate and prefer an appeal.
No, this is not an appeal, it's a writ petition, my lords.
But 30 says an appeal shall lie to the High Court.
This is appeal.
Because the order passed by the
226.
if the appellant seeks time to place the matter before the next circuit, let it come.
Let it come in the next circuit.
On the prayer of the learned advocate representing the writ petitioner, let the matter appear in the next circuit. But see, one thing, you have described yourself as the appellant.
Yes, yes, ma'am. That's why I said.
That man is a mistake, my lords.
Then correct it.
We'll correct it, my lords. I don't know where I had made a correction, in fact.
If an order passed by the commissioner, it only appeal lies before the High Court. Act says so.
Oh, no, 226 can never be excluded.
But
How can
226
226 be excluded? Alternative remedy is only a matter
You
of.
cannot challenge
feature.
an order passed under the Compensation Act.
Anyway, next matter.
Any act can be challenged under 226. Jurisdiction is very wide.
Item number 13.
Your Lordship, I am for the petitioner. Here I am seeking for an interim relief, Your Lordship. The case is that, Your Lordship.
Are the respondents represented?
Yes, yes, my lords,
All.
yes, ma'am.
Yes, what is the matter?
Your Lordship, matter is that the authorities have decided to distribute the raw cane in a manner that they have framed the guidelines in 2008. In terms of that guidelines, in 2009, the PCCF, the matter went up to the Lieutenant Governor. It was approved that the distribution should be rationalized. Equal distribution should be there with regard to raw cane, and all units, it would be unit-wise distribution. South Andaman, 19 units are there. Havelock, 0 units are there. And there are Havelock, 2 units are there. Baratang, 3 units are there. So different units are there. Means in some other places, the units, there is a differentiation between the units. Now, considering that fact, the total production was taken into consideration by the PCCF. Then what the PCCF used to do, he used to direct the DFO, that is a divisional forest officer of a concerned area, by making an equal distribution that the party, that unit can collect the raw cane from the that particular division. For example, there are 19 units in South Andaman. There are only 3 units in Baratang. Now, what the PCCF used to do, whatever the total production is there, I'm giving only an example. South Andaman and this Baratang total production is counted, and thereafter, if it is found that the production in Baratang is more than South Andaman, that the unit which is operating in South Andaman is directed that you can go and collect it from Baratang, so that it will be rationalized and distribution will be equal. So that was decision was taken, and it went on from 2019 till 2021. This was the method. All units were happy because they were getting equal amount of raw cane. In 2021, the additional PCCF on his own made a noting in the note sheet, and it was mentioned in the note sheet that hereafter the division should not be unit wise, it should be division wise. Means if it in South Andaman 19 division are there, whatever production is there in South Andaman, that will be distributed among 19. And if in Baratang only 2 divisions is there, whatever production is there in Baratang, it will be distributed among those 2 divisions. So unequal distribution will be there. That decision I have challenged. And this particular decision, though it was taken in 2021, but actual distribution, because of COVID and all, actual distribution occurred only once in 2022. That also very minor. So there was no occasion for the petitioner to challenge that. Now COVID and all is over. 23rd April 2023, the authorities have passed the order for distribution, because year-wise decision is taken. This year also, what they have done this year, they have taken a decision to divide it division-wise. And from 1st September till 15th September, the order will be issued by the DFO for division, for the distribution of the raw cane. So there is urgency, Your Lordship. My contentions I will show from the.
You are in which division?
I am in Middle Andaman division.
All right. But then did you make the other division owners or whoever the units as parties, because any order passed here will adversely affect them.
Your Lordship, these are the decisions of the authority, policy decision which has been taken.
Policy
based on the basis of
decision.
the guidelines. Guidelines never say
So-
that it should be division wise. And after the guidelines also.
Let us come to that.
Yes, Your Lordship. Kindly come to one by one, I'll show the papers, Your Lordship. Because once allotment is done, this entire year will go, Your Lordship.
Entire year.
Year, next year it will be allotted.
It's yearly wise.
Year wise. It will be next year. Now, Your Lordship, guidelines, it has page number 26. The decision is there, Honorable Supreme Court in various, the latest, not latest wing, but 2012, the 2G spectrum case. In detail, it has been decided, Your Lordship, that how the resources have to be distributed. 26 is the guideline.
Yes.
Now, Your Lordship, the kindly see guidelines for issuing of cane permit to SSI units with effect from 1/4/2008. Now, Your Lordship, these are the guidelines which were framed, but nowhere it is mentioned that the DFO is required to distribute the
Show the relevant guideline.
Your Lordship, this is from the entire thing is there. I didn't find anywhere in the guideline that any restriction is there with the DFO that he has to distribute the cane in his division only.
Where is the provision for distribution?
Provision for distribution is there. Your Lordship, the procedure is mentioned here.
Yes.
DFO will survey the unit and prepare a list of unregistered, registered, non-operational units during the period ending March 2008. Registered SSI units which are already under operation will submit application to DFO between 1 to 30th June along with a copy of registration certificate. Depending on the number of operational units, DFO will tentatively calculate the quota of cane in running meter that will be considered for allotment to each unit during the year 2008-2009. On receipt of the application, the same will be scrutinized and valid application will be serially numbered in the divisional office and an acknowledgement in receipt of the application duly indicating serial number will be given to the applicant. All application received of the 30th June will be processed during July, August, and allotment order will be issued by the DFO by 15th September. Each year 15th September. By 15th September, it will be issued. The applicant will deposit a royalty amount to RO DFO office concerned within 15 days of receipt of allotment order. Initial collection time of cane will be 3 months from 1st October 31st January of the year. One-time extension will be considered by DFO for a maximum period of 2 months from 1st January 31st March of the following year, subject to the condition that royalty has been deposited within the stipulated period. No further extension of the permit beyond 31st March will be allowed, and the quantity not collected will be lapsed and corresponding royalty deposited will be forfeited. DFO will discourage issue of permit during 1st April to 30th June. However, in case of extreme urgency of individual consumption for bona fide use, he may consider the same for a maximum quantity of 1000 RMP running meter time with condition that such permit will expire on 30th June and no extension of permit will be considered under any circumstances. In case of SSI units applying for cane allotment for commercial purpose, issue of permit will be considered from 1st September to 15th September as per clause 5. We come within this one. Request for extension of time for collecting of cane will be submitted by the permit holder to the range officer.
No, is there any specific provision?
No, Your Lordship. That's what these are the guidelines. But they have taken a decision which is reflected here. Your Lordship, may kindly come to page number 40.
This is the impugned one. Page 40?
No, not impugned one.
This
I'm
is not
showing the
impugned.
decision. Page
All
number
right.
40 is the note sheet. In the meeting convened, Your Lordship.
Yes.
In the meeting convened by PCCF on 26 August 2009 to discuss regarding allotment of cane to SSI cane units therein, it was decided that harvestable quantity of cane will be equally distributed among the units after keeping 10% of harvestable quantity to meet individuals' public demand for domestic consumption. After keeping 10% aloof, the remaining 90% will be distributed equally among the units. Now, Your Lordship, this decision was taken by the PCCF, which has been thereafter approval has also been granted, Your Lordship. It was finalized. It was based upon a letter which was issued by the Directorate of Industry, because all units, these are MSME units. These MSME units are registered with the Directorate of Industry. Now, Directorate of Industries has issued a letter which is at page number 30. Kindly come to page number 30, Your Lordship. Kind reference is invited to the minutes of the meeting held on 27 July 2009 under the chairmanship of Chief Secretary, Andaman Nicobar Administration on development of handicrafts in Andaman Nicobar Islands. It was decided and that the Forest Department will rationalize the distribution system of cane and bamboo for supply of entitlement quantity of 2000 RMP to all handicraft units. It is therefore requested to expedite the matter and an action report to be sent to the undersigned for publishing a report to the administration. So rationalization, they have decided to rationalize it, and thereafter one letter was written by the Director of Industries to the Forest Department. Then on the basis of this letter, the decision was taken, which is at page number 40. PCC have decided that it should be in the manner that equally it will be distributed. This went on. These are the, I'll show your lordship, from page number 57 to page number 72. From 2009 to 2019, this was the method which was followed. Yes. The last one I am showing, 2019 one, kindly see to the page number 72. Uh, 72, in order to make the rational allotment of cane for the year 2019-20, various factors, that is total harvestable quantity of cane, species wise breakup, and its distribution in various divisions, total number of registered SSI units, functioning within the divisions, marketability of different categories of canes by SSI units, etc. were considered. Accordingly, it is decided with the competent authority to restrict the allotment within the following tentative breakup of categories of cane. Now, your lordship may kindly see here. Middle Andaman, the unit in Middle Andaman, they can collect it from Middle Andaman, South Andaman, Baratan. Considering the production, because Baratan, we have more production. Then South Andaman, South Andaman. Diglipur, Mayabandar, Baratan. So that way, they have decided that it should be distributed in this manner. Now, your lordship, may kindly come to the decision of the PCCF. This is at, in the note sheet only he has mentioned, page number 47. We may inform, 47, we may inform the DFO, the approved for para 146 to 149, we may dispense with the unit-wise distribution in table 4 as it is for the division to regulate the allotment after considering the installed capacity, working capacity of the unit, its functional status, past record, etc., keeping the overall equity in mind. This would generate due competition in the market. We may advise the DFO to keep the priority in mind for critical development activities of the government departments and the needs of the common man, please. Now, you also, one thing is very clear. PCCF has held that unit-wise distribution should be dispensed with, and it should be division-wise. That is very clearly mentioned. Now, your lordship, they were required as per this, division-wise will be there. Now, your lordship may kindly come to one thing I want to show. Just for the sake of showing the number of units. Page number 43, your lordship, may kindly come. Just to show the number of units. Kindly, South Andaman, 19 units. Middle Andaman, 30 units. Mayabandar, 7. Diglipur, 25. Baratan, 2 units. Havelock, 2 units. Little Andaman, 5 units. Now, kindly see the production. South Andaman, 35,806. Middle Andaman, 44,000. Mayabandar, 85,000. Diglipur, 52,000. Baratan, 1,30,000. And Havelock, it is 0. And Little Andaman, 58,400. And this 0 remained. Till today, it is 0 only. So if the order of the PCCF is implemented strictly, then Havelock unit will get nothing. That is the meaning. Division-wise and unit-wise. But what they are doing, I'll show after the order of the PCCF. Kindly come to page number 78. Strictly speaking, your lordship, if it is division wise, then whatever units exist in that particular division, only they will get. Other unit cannot get it. Now 78, the entire authority practically the PCCF is giving it to the DFO. DFO will decide that whether to which unit he will give and to which unit he will not give. The resources have to be distributed equally. That is the second law. Article 40 violation is very clear if it is not. So how can the earlier system of unit-wise distribution can be changed to division-wise distribution, giving entire power to DFO? That you will do as per your wish. Now, Your Lordship may kindly see, this is the letter which has been issued by the DFO Planning and Monitoring. What he said. With reference to the set, now kindly see the South Andaman, I have just shown Your Lordship how many units are there in a particular division. Now here Your Lordship, the production is shown. Here also, if Your Lordship would see page number 78, the production in Baratang is 1,30,000 something. This is of 2021. Because after the decision of the PCCF, this is the first order. Now, Your Lordship may kindly see here, I am directed to inform that allotment for the year 2021 shall be done by the concerned DFO as per guideline 2008, in addition to the following. The harvest of cane to be restricted to the actual availability of permitted yield as per working plan, whichever less is, and deviation along with justification shall be reported to working plan officer. DFO should specify the allotment to SSI units and others are non-transferable and automatically shall lapse if not harvested within the specified time period as modified in the extant guidelines dated 1/4/2008. Now, kindly see here. Location for collection of cane for the SSI unit would be as follows. South Andaman, South Andaman. Irrespective of production. Baratang, there are only 2 units, Baratang. Now here, Middle Andaman, they were supposed to collect it from Middle Andaman, Baratang, Mayabandar because the maximum units are there in Middle Andaman. 30 units are there. Then Mayabandar, Diglipur, Mayabandar, Havelock, Baratang, Little Andaman, Little Andaman. Now, Your Lordship, as per their wish, they are changing. Havelock, they are saying from Baratang also you can collect.
No, because Baratang has the most production.
That's what I am submitting, Your Lordship. If you are intending to give to a particular area to Baratang, the method of equal distribution, which was prevailing for last 10 years, that was the best one. Why? As per your selection, that you will select. Then what happened, Your Lordship? Then page number 80, Your Lordship, kindly come. Page number 8, corrigendum was issued that Middle Andaman will collect it from Middle Andaman only, not from Baratang. Now, Baratang, Your Lordship, I have shown. Kindly see the distribution here. South Andaman, it is 1,36,000. Mayabandar, 71,000. Baratang, 2,74,000.
Where are you reading?
Your Lordship, just page number 80.
Yes, page 80.
Baratang, the total.
Baratang BTS 2,74,000.
Yes, Middle Andaman 71,000. South Andaman 1,36,000. And last Mayabandar 51,000. Now, as per the units, what I have shown, Baratang there are only 2 divisions.
All right.
And Middle Andaman there are 30 divisions. Now, how can there will be equal distribution, Your Lordship? In a unit which is operating in Baratang, they will get more than 1 lakh running meter. Whereas a unit which is working in Middle Andaman, we can divide by 30, it will be hardly 10,000, not even 10,000. Not even 10,000, it will be around 5,000, something like that. Difference may be seen. One unit will be getting 1 lakh and another unit will be getting only 5,000 running meter. So whether resources are distributed equally.
Yes.
Now, Your Lordship, so because it was during the COVID period, Your Lordship, this particular, and that year finishes because it is year wise only. That year finished. Now, the second, this next one is page number 81. Page number 81. Yes. Now, Your Lordship, the same position in 2022. But again, Your Lordship, it was something in January 2022. So that time there was certain problems relating to COVID, Your Lordship. People even they did not get properly the rocking, and could not even the petitioner could not do anything due to the COVID situation. Now, Your Lordship, this is but the petitioner, what he did, he submitted representation so that in future it should not be done. These representations are from page number 82. Page number 80 to 104. Not 104, it is up to
Only one representation.
no many one writ petitioner has been submitting the representation.
Separate representations. It starts from 83, 22nd of August 2022.
Yes, the number of representations he has submitted. So that,
15.
yes,
Pages, 15 pages.
so that in the next year, your lordship, there may be certain changes.
Yes.
Now, your lordship, the
Where is the proof of service of this representation?
your lordship,
22nd August 2022.
the proof is at page number 101. This is the letter which has been written by the conservator of forest to the Inspector General of Forest Subdivision, Ministry of Affairs. There they have mentioned about my representation.
All right.
Just I'm reading the first line. I am directed to refer to a letter cited above, through which a copy of the representation dated 22nd August 2022 received from Shri Ganesh Das Kothari, proprietor of this. Now, your lordship, they have placed the matter before the ministry. Now, kindly, I am just placing that whatever I am saying with regard to the initial development and subsequent procedure, what they have followed is reflected here.
Thereafter, what happened?
Your lordship, thereafter, they have not considered again the same order, which is at page number 105.
IG has not considered.
No. Still pending with the authorities. After that, nothing happened.
Authorities means the IG, the Inspector General of Forests.
Yes. Inspector General of Forest, they have given the forwarding, whatever the materials are
The
there.
PCCF has forwarded to the IG
IG.
in September 2022.
Yes. The same is still pending here. No decision has taken place. Because that has not been communicated to me. So I'm not aware any decision is taken or not. As it has not been communicated to me, your lordship, I am saying that no decision has been taken. In any circumstances, page number 105, this is the impugned order, your lordship, which I am challenging and which I am praying that there should be a stay of this particular order till the matter is decided.
Yes, please.
Now, here again, kindly see, your lordship. The production is given here. South Andaman, 1,36,000 with this, and Baratan 2,74,000, and this Middle Andaman 71,000. Almost similar, your lordship, almost similar. Now, your lordship, may kindly see the distribution. They have said, I am directed to inform that allotment of cane shall be done by the DFO concerned as per the guidelines. Subject to this, DFO should specify that allotment to SSA and other are non-transferable and automatically distinct. Then, just a minute. Advisory on allotment of cane issued by the office order. This is 13th May 2022. Shall be strictly followed. Same manner, South Andaman, that way. So that's why they have written in that manner. And then, just a minute. I have submitted so many representations. All representations after that also, from page number 107 to 134, those representations are pending.
Yes.
My lords, this is the most serious matter, my lords, and although
Most
it is
serious?
yes, my lord, it's a matter of utmost seriousness. And in fact, the officer has prepared a very competent note. I'll place the case from this, my lords. Only one copy.
Yes.
My lords, the decision which has been first, my lord, there is a larger legal point, and second is the factual point. Before I come to the note, the larger legal point is, my lords, the decisions that have been taken are in compliance with the Supreme Court's directives in Godavarman case, which occupies the field so far as any kind of activity in the forest land is concerned, forest area is concerned, my lords. I'll place that, and we cannot tread or take a different path from that. We have to follow the directives of the Supreme Court and the working plans which are in terms of those directives. But that is the larger legal point which I'll make. But the factual point is, my lords, that this petition, my lords, with the greatest of respect, as far as the department understands the facts, is an attempt to create a monopoly, my lords. The reason being that, my lords, I'll just explain how the system, that is my understanding, I may be wrong, my learned senior will correct. The system that used to work earlier was like this kinds, my lords. If the allocation is made in terms of units, then what happens is every unit has a different requirement. So invariably lot of units will receive more cane than they need. So what would happen in that case is a couple of big, in fact, this is the only petitioner. None of the other parties have come before the court. So I'm making a submission. So the instruction is that only this party is affected. The reason being that it had such a kind of a dominance in the market that it would buy out the cane from every other unit, whichever unit got more than it required. Now, representation was made on behalf of the entire industry, and they have not been made parties here, to say that look, one corporate entity is taking away everything, and even otherwise, the interest of the working plan clearly shows that the interest of every division the requirements have to be seen. What is the requirement for government projects? What are the requirements for development works? What is the requirement of cane in a particular area? Division wise has to be seen. Now, to meet that, to me, and rather than just one corporate entity buying it out and then selling it, sending it for export without the island benefiting from that. So these were the larger policy considerations in which this decision was taken. Actually, my lords, there is no prejudice whatsoever, because if my lord sees that, first of all, they have lived with this new system since 2020 to 2021. Fairly, my learned senior has placed 21, the same system was there, 22, the same system was there, 23, 24, the same system is there. So there is no, in the greatest of respect, there is no scope for interim order. If they live for 2 years, they can very well wait till I file my affidavit. I'm not saying that there is no legal question that requires to be seen, my lords. I'm not saying that. Now, my lords will now see that what is the prejudice. Before I come to the legal point, because I'm addressing on interim relief, page 105 may be seen, my lords. And it may be borne in mind that the petitioner is operating in Middle Andaman. So the petitioners cannot raise an issue so far as their unit is in Middle Andaman. Now, Middle Andaman is getting a designated quantity of cane. Now, the scheme, how it works now is, if any division has excess, that division, the surplus can be, another division can take it from that division. So, for example, if the requirement of Middle Andaman is 30,000, but and on the other hand, the Baratang receives 20,000 and Baratang receives 5,000 in excess, then Baratang can always give it to Middle Andaman. So because now the only difference is that instead of looking at requirement of each unit, what is being looked at is requirement of each division, because one has to see what are the local requirements, what are the development projects that are going on. And secondly, nothing stops the petitioner from opening an MSME unit if they have so much of requirement and if they need so much of cane, nothing stops them from getting a registration in the other division. Their objective is that they will buy from each unit on commercial terms and then they'll sell it off. That is the concern that has been, because that explains why the only one party has approached the court. Now, my lords, coming to the legal point, my lords may just have this note, and I'll place the relevant documents one by one. My lords, first, the Honorable Supreme Court's order in Godavarman's case. I'll just share a copy with the court and with my learned senior. Now, my lord may straight away come to the directions which are issued. The directions begin from page 7, and my lords will see, after taking all facts and circumstances, we issue the following directions, and Arabic 4, page 8. Now, my lords will see 4, 5, 6. First is 4 is no felling of tree under the working plan or otherwise shall be permitted for meeting any raw material requirements of plywood, etc., or any other wood-based industry. Then 5, the drawing up of the new working plan, the government shall formulate a committee who is proficient with ecology or Andaman. The working plan so formulated shall be placed before this court within a period of 12 weeks. So every working plan initially had to be placed before the Supreme Court. That was the original order. Now, this order was subsequently modified by the Supreme Court in a later decision. This is an order in the same case, my lords. Now, my lords may have page number 10. Now, this order was modified, and my lords may see under IA 908 and 922. An IA has been filed in this court on behalf of Administrator Rajnivas, Andaman and Nicobar Islands. Let the working plan prepared by the Union Territory be placed before Ministry of Environment and Forest for consideration within 6 weeks.
And in case it is cleared by MOEF, the same shall be placed before Central Empowered Committee for consideration within 6 weeks. Now, after this, what happens is instead of the working plan being placed each time for approval before the Supreme Court, it is first placed before Ministry and then it is placed before the Central Empowered Committee. Now, the working plan, for example, just to explain how this system works, the Empowered Committee, my lords, approves the working plan from time to time. So this is a working. Yes, it's a Supreme Court appointed Empowered Committee. So for example, my lords, we'll see the working plan for 2018. This is in fact the concerned working plan also. Now this working plan is approved, is approved by the Central Empowered Committee. Just to show that much I am relying on this. Now my lords may see the working plan, the concerned working plan. This I'll hand over the hard copy, my lords. I have one. I'll into photocopy, ma'am. Iska copy. My lords, I'm just handing over this book. This is the working plan for period from 2017-18 to 2026-27, and I've flagged the relevant portion. Ma'am, ke liye copy. Iska copy. Now, if my lord sees, this is for one division. Similar we have for the other division also. There is the portion which is flagged. Now, my lords may just see the flagged portion. 2.9.18. Internal page, you have 310. 2.9.18. Cane areas restock themselves naturally. The flagged page, just the page before that. Cane areas restock, my lords, there is a page which is flagged in that book.
Yes.
And just the page before that, cane areas restock 2.9.8 para number. Cane areas restock themselves naturally. Profit protection from cattle and pigs is given. There is necessity to restock the under 2.9.15. Sorry, my lords. One page before. 2.9.15. The cane shall be collected on 10-year cutting cycle basis as prescribed in para 2.9.13 above. The total potential cane area is this much. Total harvestable quantity of cane is this much. Therefore, the quantity of cane could be collected from the annual cut during the working plan period. Running meter out of such and such is prescribed as utilizable annual yield to meet the requirement of various departments, cane-based small-scale industries and local inhabitants of the division. However, in case of surplus quantity of cane, the same can be adjusted against another division, which are deficient in cane potential area. Yield control will be by area and available matured cane only and not by quantity of cane needed or assessed above. So as per the working plan, the administration, the forest department has to look at the requirement of each division, the inhabitants of each division and the industries of each division, and the yield also will be as per the division. So therefore, my lords, in case there is surplus, as per the requirement of another division, division to division transfer can take place. This is what the working plan provides. Now, my lord, similarly, there is a similar, I'll just for the purpose of completeness, similarly, for the Middle Andaman division also, similar provision is made. Okay. Similar, my lords, I'll not bother your lordships. My lords can take it from me that the requirement is the same, that it has to be division-wise and the interest of each division has to be seen. Now, my lords may see the impugn, my lords, the note sheet which has been page 77. Page 77, my lords. What is the decision that is taken? We may inform the DFO. My learned senior has already read. We may dispense with unit-wise distribution as it is for the divisions to regulate the allotment after considering the installed capacity, working capacities of the unit, its functional status, past record, etc., keeping the overall equity in mind. This would generate due competition in the market. We may advise the DFO to keep the principle in mind for critical development activities of the government departments and need of the common man. So in terms of the working plan, a decision is taken that this distribution has to be per division. Of course, if there is a surplus division to division, it can go. Now, my lords will see, my learned senior had shown the first decision.
One thing, suppose the unit of the petitioner requires more cane.
My lord.
Can he make application?
Through Middle Andaman DFO, he can make a request.
He has to satisfy the,
That
requi-
this
the
is
develop, it is
requirement.
required for bona fide development
Yes.
activity, not for export, my lord. There's a difference in the.
No, export,
So-
export is bad.
No.
What you're saying?
Export, I'm sorry, export is a wrong word. What by export I mean, what would happen is it would go to the mainland and then it will be processed and.
No.
Those are my, anyway, that is a factual aspect. I'll not.
If the unit requires.
They can always tell the DFO, the local, the
This is
DFO.
my
can-
requirement.
and the DFO will
can
process
always-
from the other division, he'll seek it. It is only rampant commercialization is being sought to be stopped so that the requirement of the division can be met.
Very well.
Now, anyway, I am only
What I'm
submitting.
submitting is, suppose your lordship, 2 units in Barata, they are making application that they require 1 lakh running meter. So whether the DFO of Baratang will reduce it to a considerable extent so that the other units which were getting 5,000 only or 500 only, can they?
Why
get
are
it?
you considered with other units?
That
You
is what
say,
is happening.
listen, you require say 10
Yeah, Lord.
and according to this note sheet, you are given 5. You require 5 more. The respondent says that if you make an application, they will consider.
Your lordship,
Where is the difficulty?
your lordship, just a minute.
Yes, madam. Export takes place. My instructions are, it's not correct that there is no export. Export takes place. Semi-processed is export.
Your lordship, that is what my client is saying.
What?
That what they will do, they first of all,
What they will do is something
No,
else,
your
but this is permissible. You can always make an
I will
application.
make an application, but as per the letter, one letter is there. It says, your lordship, that after finishing the demand of their unit first, then only demand of other unit will be considered. So there cannot be any equal distribution. I will never
No,
take it.
if there is a demand, they can always arrange from any place where it is in surplus.
Yes.
Your
Not
lordship,
necessarily.
surplus word will be there, your lordship, only if the distribution to that particular unit. Suppose in Barakan, 2 units are there. Their production is 2 lakhs. The units, both the units are demanding 1 lakh, 1 lakh. How can I get?
You will get it from some other division.
Some other division, there is no production at all. Their production is much lesser than our production. That's what I'm showing it. Baratal and South Andaman, the production is more. But South Andaman, there are 19 units. Baratal, there is only 2 units. And those 2 units are getting 1 lakh running meter each.
Suppose 1 lakh running meter is made available to the 2 units and they do not require it. What will they do with that cane?
They require it, your lordship. They are making, as per this particular order, what the 23rd April order is there. They are coming to know about the running meter production. They are making according that we want 274 divided by 2. 1 unit will be writing like that. Other unit also will write like that. That is what is happening.
No, but then do you mean to say that they will collect the raw cane even if it is not required?
Even if it is not required.
For what purpose?
Because
I fail to understand.
Commercial production, no, your lordship, it is commercial production. That 1 lakh running meter, they require it. They are how much they can get it?
See, raw cane is supplied to y'all, right? Then what do y'all do with it? Y'all make furnitures.
Make furnitures.
Right?
Yes.
So if the unit doesn't have that capacity
They have
to
that
utilize 1 lakh meter running meter, then what will
They have their capacity. Not only that, if they are not able to do it, they will sell it in a high price in outer market. This is black marketing. What is going on? If that equal distribution was there, that consumption was within the unit itself. But if that particular, my learned friend himself has said that I am doing monopoly, I am purchasing it from all other units. This goes to show what is happening there. That if that surplus they are getting it, that we are not required to purchase it. One thing has to be kept in mind. We are not required to pay anything to them. It's only royalty. It's not an auction. So I will get 1 lakh. And then I will sell that 1 lakh. Whatever my consumption is, that remaining, I will give it to the other unit in a higher price. That is what is happening. And it has been admitted by the other side that I am doing that. I am not required to do that. Because I think equal distribution. I don't want that.
No, you want equal distribution within the units, and the authorities, they want to distribute it according to the division.
According to the division.
Right.
Baratal division, the production is very high. No, only 2 units get it. And those 2 units practically creates monopoly. And they will sell it in.
No, but then that was not there. It is coming very recently. How do you know that they are making monopoly or something of that sort?
This is the third time. 2021, once it took place, 2022, and then this is 23. And those 2 years, I could not do anything because of COVID. Otherwise, I would have approached the Hon'ble.
The other unit holders also could not move forward because of COVID. It is not that the COVID was only with you.
No,
Others, everybody was affected with
that
it.
is true. Your
That is for everybody.
But somebody,
Right.
somebody is coming before this court, Your Lordship.
No,
They are not
you
very
may
big
come.
units.
But then for the purpose of interim order, how much the court will entertain, this is what I am thinking.
Your Lordship,
The authorities,
currently it can be fixed in the next circuit for final hearing. 15 days, nothing is going to happen. But if once the allotment is done, entire year will go. Entire year, my entire year will go. Next year only, if something happens, then I can get it. So 15 days, nothing is going to happen.
My lords, this was there, this was implemented for 2 years, 3 years they have been living with this system. My lord.
No, Your
This is not
And
20,
file your opposition, you have already prepared the note.
my lord.
The note
Not
is-
peremptory, my lord, just because.
I won't mention peremptory. You at
Not
least
a-
file your opposition because at this stage, what is the interim relief that
Yes,
can be given to you? This is what
My
I was wondering.
Your Lordship, my submission is that, Your Lordship, interim relief in the nature that at least by 18th or 19th September, till the next circuit, the case should not be released.
No,
Then it will be wasted or
it will.
No, it is not. What to say?
This is also in it.
No, my lords, my lords, please appreciate what I'm submitting, my lords. We have actually the new system, if I am correct in my understanding, my lords, the new system is actually in the interest of the max. That is why none of them have challenged.
No, sir, it is not.
No, it is only one
That
party.
I don't see.
It is, no, how can this be stopped?
It's very clear.
How can, no, my lord, just appreciate for a moment. What is the problem my learned senior has said the other units will get and they have the capacity. So what is the problem with that, my lord? All units should get, so it's clearly private, this is clearly private interest, my lord, nothing more. This is not-
Judgment of the Honorable Supreme Court in this line. The Honorable Supreme Court has held very clearly that all natural resources should be distributed equally.
That is exactly what we are doing.
No, you.
As per the requirements of the division.
Your Lordship, I am just.
We'll file our affidavit, my lord.
I am praying, Your Lordship, that the order dated 23rd April, that may be stayed for a very limited.
Oh, my lord.
no, because this is going to affect others. This is
They
the
are not
reason
even
the
parties, my
authority is
lords.
not inclined to stay this.
Then in that
Because
case,
this
Your
is-
Lordship,
Yes.
at least, Your Lordship, some amount of gain should be kept so that it can be distributed subsequently after 15 September. If
Okay.
entire 1 lakh
No,
is
no.
released to 1 unit, I will not get anything.
Their division is getting, my lords, may see page 105. I don't understand why special
I have
treatment.
just shown 30 divided by 71. How much I get?
You
The-
can
not
open
even-
it, open in the other
The
division. then.
petitioners are aggrieved by the
My lords, also, my lords, my
manner
others,
in which
let the rest be made parties also, my lords, but rest have to be made parties.
the manner in which the respondent authorities are taking steps for distribution of raw cane. Stop. According to the petitioner, the prevailing system was equal distribution unit wise, which has presently been changed. And the respondent authorities are distributing the produce division wise. Stop. The petitioner contends that in view of the division wise distribution of raw cane, comma, there is unequal distribution of the natural produce, natural resources. Stuff. Next. Prayer has been made for directing the respondent authorities to distribute raw cane unit wise as was done previously. Paragraph. Learned advocate representing the respondents oppose the prayer of the petitioners. It has been submitted that the petitioners are trying to create a monopoly. Stop. They are collecting raw cane and exporting it commercially. Stop. Next. It has been submitted that the new system has been introduced for better distribution of the natural resources. equally amongst the divisions. Stop, next. The respondent seeks time to file affidavit in the matter. Stop. Let affidavit in opposition be prepared and served upon the learned advocate representing the petitioner by 8th September. Reply, if any, by 15th. List in the next circuit.
Your Lordship, let there be an order with regard to interim relief, Your Lordship. I'm praying.
What interim?
Your Lordship, whether it is rejected or allowed, Your Lordship, let there be an order.
Only 2 days left. The next
No, Your
circuit
Lordship.
is there.
Your Lordship,
You
let
can
there
get
be
it.
civil relief. Your Lordship,
In
my
the
prayer.
next circuit,
Your Lordship.
either an appeal will come or this will be heard.
Your Lordship, kindly consider. Your Lordship,
I have followed your
No,
submission.
the problem
The
is that.
tenor of your submission.
No, the problem is that
Showing-
my client is interested to go for an appeal challenge.
Yes,
This order,
this-
he wants
this-
to go.
You can always go with
Your Lordship,
this.
without any, my prayer may be seen, Your Lordship. I'm praying for an interim relief. Either it may be allowed or rejected, Your Lordship, but something order should be there. Your Lordship, let there be one order. Interim relief will be considered in the next session.
Yes.
Let there be order.
Yes. The prayer for interim relief
Your Lordship.
may be made before the next available, sir.
Your Lordship. Obliged.
There is a matter fixed.
My lord. Be proper to mention, my lord. I can mention it again tomorrow before the or division bench will sit, my lord. No,
Yes.
I'll make a mention, my lord. I just wanted to file one judgment, my lord.
One matter was argued yesterday by Vijay Gopal regarding relaxation clause 5.
All right.
Vijay Gopal had appeared on the other side. I had made an argument regarding policy decision matter. I just wanted to find.
Has it been reserved for judgment?
Reserved, but the only aid of the argument which I made. It's not a new argument.
All right.
It's one statement I wanted to have.
Is Mr. Binu Kumar aware
He
of
doesn't have
this?
any objection.
Let us see once.
I've already made this argument. So just from the scope of judicial review and policy.
Which paragraph will you be
It's mentioned
referring
that
to?
was on top 60.
Oh, 60 to 76.
I had informed him also, he doesn't have an objection.
Very well. এটা ওই ফাইলের সাথে বেঁধে দিতে হবে।
My learned friend,
Just one second. Just one second. No, these are. No, this, I have prepared the compromise application Sulenama. What where we agreed, we have reduced in writing. Not can have it has not been signed yet. Because the other side have some problem with the, so kindly see the terms, it is in consonance with what we have agreed yesterday.
I read so many things, but everything is not reduced in.
Not reduced in
No,
writing. Why don't you all sit together and reduce it in writing? So that it is.
Everything has been covered. He wants something more, which has not been discussed.
What has not been covered?
My friend's client submitted that regarding the marriage of the daughter in the future, we will arrange something. Nothing is, there is no whisper.
That 40 lakhs, 40 lakhs, only they have agreed for 40 lakhs.
That, number one. Number two, page 3 may be seen. I.
It is not paginated also.
It's a.
Page 3, II. Yes.
Check date may be seen 10/11/2023.
No. Would you like the live streaming to be stopped?
Yes, Mona, yes.
Would you
Yes,
like
yes,
it to be
yes,
stopped?
Yes, yes, Mona, yes.
Then please stop it.
Yes, yes.